afternoon, everyone. I'll say that again. Good afternoon, everyone. Welcome to the Appellate Division First Department. We pride ourselves on being on time, but when we have to supply masks, we have to wait a little bit. So please remember, bring your masks. We still have to wear them. We have approximately 7.5 hours of argument today, so please keep that in mind. As I call the calendar, please only ask for the time that you need to make your argument. Remember that we have your briefs, we have the record, we are fully familiar with the facts of your case. So with that, I'll call the calendar. People versus Eliseo de la Cruz. Excuse me? 6, 2, and 6. Thank you. Garcia versus BLS Limousine.
Good afternoon. For the appellants, 6 and 2, please.
6, 2, and 4. Thank you. Ralph DeSanto versus 200 Chelsea. 5, 1, and 4. Thank you. People versus Anthony Griffith. 3, 1, and 3. Thank you. Simmons Machine versus Skanska. 8, 2, 4, and 3. Thank you. McKenzie versus Penn New Jersey Transit. Submitted. People versus Alex Lino. 4, 2, and 4. Thank you. Drame versus 1650 Bushwick. 5, 2, and 5. Thank you. Maltese versus Port Authority. 5, 2, and 3. Thank you. People versus DeCourcy Bell. 6, 2, and 6. Thank you. Stewart versus Woolman Rink. 7, 3, and 5. Thank you. Tradesman Program versus Doyle. 5, 1, and 4. Thank you. 71 Lafayette versus New York Marine. Do you want to submit? I think we're okay. Thank you very much. U.S. Bank versus Tiburcio or Tuberico.
The appellant, 6 minutes, please.
And respondent? So, do you want to submit? There's no one else here. Okay, I'll give you 2 minutes. 2 minutes and a submission. People versus Clifton Solomon. 4, 1, and 4. Gibbs versus Lehman Manhattan.
Request 6 and 2, Your Honor.
6, 2, and 5. Thank you. Coelho versus 708 Tremont Realty. Submitted. 3rd and 60th Associates versus 3rd Avenue.
Request 6 and 2, Your Honor.
6, 2, and 5. And Barisha versus Tosca Cafe is adjourned. First case for argument is People versus Alessio de la Cruz.
Good afternoon. May it please the court, Zoe Root on behalf of Alessio de la Cruz. Over the course of this 4-day trial, the prosecution played a video of Mr. de la Cruz holding a gun at least 6 times. The trial court failed to inform the jury that Mr. de la Cruz was not charged with the gun possession depicted in the video. In fact, the court's instruction suggested that the jury could find Mr. de la Cruz guilty of the gun possession depicted in this video. In its supplemental jury charge, the judge told the jury that Mr. de la Cruz was charged with possessing, quote, the guns that you have seen or heard about in this case. Over the course of the trial—
But wasn't it clear that they had guns in the courtroom? So they were talking about the guns that they were showing in the courtroom. And it was clear that the guns in the video that they were holding and waving weren't additional guns that they were speaking about. They were only talking about the ones that they presented into evidence in the courtroom.
Right, but there was no way that the jury could have known that the guns in the courtroom were not the guns depicted on the video. And in fact—
But whether they were or they weren't, they knew that they weren't supposed to be charged using— there was no third gun, in other words. I think there were 2 guns in the courtroom, I believe. There wasn't a third gun in the video.
Right, but there
only
was—
those 2 guns.
Right. There was no suggestion to the jury that the gun depicted in the video was one of the 2 guns or not. All the jury knew was that they had seen this video of Mr. de la Cruz holding a gun at least 6 times, and they had heard reference to the video of Mr. de la Cruz holding the gun at least 10 times. Yes.
The judge say he's charged with constructively possessing the gun, not possessing the gun, but constructively possessing the gun, making it clear that it wasn't any of the guns. He was charged with not possessing any of those guns, but constructively possessing, correct?
Yes, Judge. So while there was an instruction about constructive possession, it's very clear that the jury was confused about the concept of constructive possession. We know this because they submitted a they submitted a jury note asking the judge, can you elaborate more on constructive possession of a weapon?
And then the judge did elaborate more. Wasn't that when she went into the whole blender explanation?
Yes, he went into
So
the
then
blender.
was there another question after that that suggested confusion?
No, Judge, but there is suggestion based on the supplemental charge that the jury actually came away from that supplemental charge more confused about the concept of constructive possession. The judge said during his supplemental instruction that there are 2 ways to find someone guilty of gun possession. One way is if they have it in their hand. And Mr. de la Cruz had a gun in his hand in the video. In addition, it was during that supplemental charge that the judge said that you could find Mr. de la Cruz guilty of the guns you had seen or heard about in this case.
You
And we
seem to
know—
be arguing now that this led to, the admission of the video led to confusion. But I thought in your brief that you objected to it because you said it was evidence of an uncharged crime.
Yes, there are multiple reasons that the
But you
admission—
didn't preserve any of those reasons, did you?
So the issue here, Judge, is not— the problem is not that the video came in at all. The problem is that the way that the prosecution used the video and then the instruction that was given to the jury about the purpose of the video did not make it clear that the video could not be used against Mr. de la Cruz. And the defense attorney absolutely did request a limiting instruction, which would have cured the error, and the trial court refused to give that limiting instruction. In addition, it's clear that while the defense attorney and the prosecution and the court knew that this video had been filmed in New Jersey, and I think the people make some arguments about the question of New Jersey versus New York, that was never told to the jury. The jury was never given any information about where this video was filmed, that it had been filmed outside the jurisdiction, and most importantly, they were not given a limiting instruction saying that the contents of the video could not be held against Mr. De La Cruz.
Thank you.
Thank you.
Counsel? Yeah.
Good afternoon, and may it please the court. My name is Megan McLaughlin on behalf of the people.
I just want to ask you to start where counsel left off. Was there any testimony that came in with regard to anything about the video that would have identified where it was?
Yes, Your Honor. One of the officers absolutely testified that the video in question had taken place in Toribio's home, one of the co-defendants, and there was testimony that specifically stated that Toribio lived in New Jersey. So there was actually a search warrant that had taken place, and it was discussed that that search warrant had been executed in New Jersey.
And that came in during questioning of one of the officers?
Yes, Your Honor.
But there was nothing additional that aside from that was the evidence that came in about the video?
That was the evidence that came in that video had specifically taken place in New Jersey. However, the conversation that surrounded constructive possession, it was clarified by both the prosecution and the judge that the possession had to have taken place in New York through defendants' co-defendants. I did want to just address first and foremost, as this court has already pointed out, this argument is not preserved. And counsel addresses the defense attorney's argument that there should have been a supplemental instruction as somehow preserving this Molyneux argument, but that is simply not what happened here. The defense attorney, after the jury had already been deliberating and after they had already begun or asked about constructive possession, after that, the defense attorney asked the judge to re-instruct the jury on essentially jurisdiction. She asked the judge to clarify for the jury that the possession had to take place in New York. She did not mention anything about the video being Molyneux evidence or a limiting instruction for Molyneux purposes. So that argument is completely unpreserved. And as a matter of fact, during the entire trial, the defendant never claimed that the video constituted Molyneux evidence. And so any Molyneux arguments in this case are entirely unpreserved. Now, as to the merits of those arguments, the defendant was on trial for the attempted murder of Mr. Garcia. The evidence in question was not Molyneux evidence at all, and that is likely why nobody claimed as such during the trial. The video had been sent to the group chat and was direct evidence of the defendant's intent and that he was acting in concert with his co-defendants. One of the co-defendants was in the video, and it was at the other co-defendant's house. Defendant is in the video waving a gun around, threatening the victim, who subsequently, hours later, is shot. So this was direct evidence. It was not Molyneux evidence at all, and for that reason, it should not have been treated as such. Now, if Your Honors had any questions about the other 2 points in this case, there was a
Thank you.
summation point, and I just wanted to answer any questions.
Thank you. I think we're
Thank you, Your Honor. I'll rest on my brief.
Thank you.
Your Honors, I want to make it entirely clear that this is not a Molyneux argument. The argument here is that the prosecution introduced a video that showed Mr. De La Cruz holding a gun, and the jury had no way to know that that was not direct evidence of the gun possession charges.
Don't you make a Molyneux argument in your brief?
There is a Molyneux element, absolutely. But what I'm focusing on today...
Well, you're abandoning that now? Is that what you're telling us? You don't want us to consider any of the Molyneux issues?
No, I do think the Molyneux issues are worth considering, but what I want to focus on today is that under People v. Williams, the court had the obligation to give a limiting instruction, which is precisely what the defense asked for, and the court failed to do so. The request for the limiting instruction preserved this issue after it became clear that the prosecution was using this video to suggest that Mr. De La Cruz was guilty of gun possession, and then there was a confusing charge given to the jury that further muddled the issue, suggesting that Mr. De La Cruz could be found guilty based on the video itself. It's also very clear that the jury here was confused about a lot of things. They found him guilty of 2 charges of gun possession that were ultimately thrown out because the prosecution had never proved it. So we are faced here with a confusing jury charge, a video of Mr. De La Cruz holding a gun, and the jury throwing their lot into the likelihood that, well, we saw a video of him holding a gun, I guess we'll find him guilty of the gun possession charges. The trial court should have given, at the very least, a limiting instruction. In addition, they should have also had a hearing to determine the admissibility of the evidence and given a limiting instruction at the time the evidence was introduced. But at the very, very least, they should have given a limiting instruction at the end of the case, and the fact that they didn't is reversible error. Thank you.
Thank you. Thank you both. Garcia versus BLS Limousine.
Good afternoon, Your Honors. Catherine Beer from Morrow Lilling Naparty for the defendant, appellants BLS and Martin Mishtaku. May it please the court. It's for a jury to determine in this case whether the defendant driver, Mishtaku, was reasonably safe in opening his door and therefore whether VTL 1214 was violated. The trial court improperly determined that Mishtaku did not act in a reasonably safe manner when he opened his door just slightly, solely because he didn't check his mirrors prior to doing so.
He was on the phone, his cell phone, at the time he opened the car door, correct?
He was. He was on his phone speaking to a client and saying, I'm going to stick my arm out the door. This is where I'm parked.
You rely somewhat on the uncertified police record, but is that competent evidence?
That certainly should be considered. First, there's a number of reasons why it should. First,
Well, the officer didn't observe the accident, right?
he did not observe the accident, but he made observations of the damage to the vehicle and to the bicycle when he arrived on the scene. And based on those determinations, the damage determined that the plaintiff was traveling at a high rate of speed. And notwithstanding that, the plaintiff relied upon the police report in their own summary judgment motion. They never raised the argument that we couldn't rely on it below. And also, hearsay is permitted with respect to summary judgment motions as long as it's not the only evidence that's submitted. And in this case, that wasn't the case. And just going back to the circumstances that we need to consider, the totality of the circumstances in this case. Certainly, in a different set of circumstances, if I'm double parked in the middle of Madison Avenue and I swing my door open and I'm not looking to behind me to see if traffic is approaching, that certainly I would concede probably would not be reasonably safe.
So counsel, so your client's undisputed testimony is that he opens the door into oncoming traffic, he is not looking behind him, and he's on his phone. What other non-negligent explanation could there be? And we're not talking about what the plaintiff did, whether the plaintiff rode too fast, right? That's an issue of damages and comparative negligence. What do you have your client's own testimony is, I'm on my phone, I didn't look, and I opened the door. And what else could there be? What non-negligent explanation could there be for your client's own description?
Based on the fact that prior to that happening, he pulls up in a parking lane, which plaintiff admits is a parking lane. He parks flush along the curb. He opens his door very slightly, a couple of inches, to lift out his arm to wave to his client. He's not swinging the door open.
Well, I don't think he's flush along the curb, is he? He's in one of the spots. Is it spot right along the curb, or is it
Right along the curb.
leaving?
Right along the curb. He's parked right along the curb. There's cars parked in front of him, cars parked behind him.
Okay.
Before he opens the door, he had actually gotten out prior to that without incident, and at that time, he had ensured that he left enough space between his vehicle and the moving lane to his left. And in his mind, there was enough space for any traffic to pass safely.
Yeah, but that's not what the statute says, right? The statute says you don't open up your door into oncoming traffic without doing what you need to do. He
Unless
says
it's
he didn't
reasonably safe.
look. He says he didn't look, and he's on the phone. So that's what, I mean, I get that you're saying maybe the plaintiff was going too fast, and that's an issue of comparative negligence, but I don't know how you could come up with a non-negligent explanation for opening the car door, when you say a few inches, enough to put his arm out, and enough to hit somebody, hit the bicyclist running along. So a few inches, 3 feet, he opened up the door, and he wasn't looking, and he was on his phone. So I don't see it. What do you got?
That he's parked along the curb, and he's assuming that the vehicles and the bicyclists around him are going to obey the rules of the road, that nobody's going to be riding directly on his left. He opens the door slightly, and that's when the accident happens. So the plaintiff has to be super close to his car in order for that impact to occur. If the plaintiff was traveling 2 feet to the left, that impact doesn't occur.
Is
So
there
he-
some VTL that says a bicycle has to be a certain distance from the parked cars?
Not in the VTL, but in the New York City Department of Transportation, the course that the plaintiff was required to take, it says, make sure you maintain 3 feet. Plaintiff says that he's 2 feet from the vehicle. If he was
Again,
2
that
feet-
talks about plaintiff's comparative negligence, but it doesn't show a non-negligent explanation for what your client did.
I think the non-negligent explanation is that he's parked in an area where he believes if he just opens his door a little bit, there's enough room there for people to pass without being hit.
Okay,
And that's-
thank you. You have,
Just going to say, most accidents happen because there are things that we don't anticipate, but you have an honest client. He's telling you what he did.
he said he was off his guard, in fact. I think he said he was a little off his guard that day.
I think he said in hindsight, since the accident happened, maybe, I could have looked. And certainly he could have looked, but just because he didn't look, that doesn't necessarily mean that his actions on the date of the accident were not reasonably safe. We need to consider all the circumstances in totality.
Thank you. You have some rebuttal.
Good afternoon, and may it please the court. My name is Joel Celso on behalf of the respondent, Enrique Garcia. Your Honors, I just want to address just a couple of salient points here. First is counsel is really talking about her client's subjective belief at the time, and there's nothing in the statute, VTL 1214, that deals with anything that is subjective.
But there is something called common sense.
There may be, but the statute certainly doesn't build anything like that in. It's
No,
simply...
it doesn't. The statutes don't build common sense into them.
I'm sorry, Your Honor?
I say you're saying that the statutes don't build common sense into them.
I'm not sure that I should comment on that. But the other thing I wanted to say is that this is a conjunctive statute. What it specifically says is that no person can open the door of a motor vehicle on the side available to moving traffic unless it's reasonably safe to do so and it can be done without interfering with the movement of other traffic. Appellants have just keyed in on that the first half of that conjunctive statement and said, well, we're going to litigate, whether or not it's reasonable here on appeal. But the reality is, it's undisputed that the movement of the door, the opening of the door, interfered with the movement of traffic. The respondent was struck. So, to me, unless you ignore the conjunctive nature of the statute, which I'm certain this court will not do, it's a clear-cut violation. And Your Honors, I really don't think I need to say much more unless you have any additional questions.
About your friend's point in her brief that this is better suited to address this issue after depositions, that this motion is premature.
I mean, the depositions were completed, so I am not aware of that.
Oh, I'm sorry. One of the points was that the motion was premature. So,
Your Honor,
in your view,
I honestly don't recall that even being in the brief.
You calling me a liar?
No. No, I am not.
So maybe,
Thank you.
oh my goodness, okay.
Just very briefly, I just want to touch on the fact that the mere fact that an accident occurred is not enough to say that the statute was violated. If that was the case, then we wouldn't have the reasonably safe language in the statute. We wouldn't have these other cases where your honors have considered all the other circumstances that lead up to the accident. So the mere fact that the accident happened is not enough to say that the statute was violated and therefore that the plaintiff is entitled to summary judgment. And again, I know I'm beating a dead horse, but I do think that it's important to consider the totality of the circumstances, that the driver was, he ensured that he was parked properly, that there was enough room to his left between his vehicle and the moving lane to his left. And as your honor mentioned, there, it's common sense that, the plaintiff is not going to be riding alongside cars that doors could be opening. And when you park, you have the expectation that if you open your door a little bit, you're not going to smash into somebody. There's not going to be a vehicle or a bicycle traveling right alongside of you. So unless your honors have any other questions, we'll rest on our brief.
Thank you.
Thank you.
Thank you both. Ralph DeSanto, versus 200 Chelsea.
Good afternoon, Your Honors. May it please the Court. Irina Kravchenko, I represent Defendant Appellant on this appeal. It is the appellant's contention that the Supreme Court erred in denying its motion for summary judgment on the facts of this case. First of all, it is uncontroverted that the alleged hole or depression in the cement on which plaintiff claims she tripped was located entirely and solely on the sidewalk in front of the abutting premises with which my client, the bakery, had no relationship whatsoever. The motion court disagreed with it based upon a misconception that the photographs was the only evidence showing that. However, that is simply untrue. The photographs in the record were supported by the testimony of every single witness, including plaintiff herself, both the owner of both premises, as well as my client, the tenant, as to one of the premises. Most specifically, plaintiff repeatedly and unequivocally identified the location of her fall that as she called, cement was missing from the location of the sidewalk, as located only to one side of a line appearing on every single photograph. Now, that line is the expansion joint between the sidewalk that separates the sidewalk between the two properties. On the one hand, there is a property leased by my client, and on the other side, there is the property owned by the co-defendant. The photographs unequivocally show that the sidewalk in front of the property leased by my client was clear, was completely repaired, had no defects whatsoever. This testimony was furthered by the owner's testimony and the bakery's testimony in conjunction with other photographs showing that this expansion joint went all along the sidewalk and then up the buildings, where you can clearly see the distinction.
Mr. Sato was the principal of Shigematsu, right?
Correct.
And he said that he made repairs, but not on the meatball side, essentially. Correct? That's his testimony.
Yes, that is correct, Your Honor. Absolutely. That goes to the second point made by co-defendant, which is unsupported in the record, that my client created this condition. Mr. Sato could not have been clearer, again referring to the same photograph showing his sidewalk free of defect. Yes, I repaired this. This is the only repair I did, and did you do any work on the other side of this expansion joint? And the answer was no. So there is no creation issue in addition to the defect being solely located on the other premises with which my client had nothing to do. Now, at the very least, summary judgment should have been granted with respect to plaintiff as well as the contribution cross-claims based upon the absence of duty. This law is well settled on this point, that a lessor does not have an obligation to maintain this, the lessor does not have a duty to the plaintiff with respect to the sidewalk, irrespective of the language in the lease. The lower court misapplied the Second Department case to the facts of this case to find otherwise, which was problematic for two reasons. First of all, none of the respondents actually raised the displacement of duty Espinal exception, which is important because this court should not consider that argument without it having been raised below, as the appellate divisions have repeatedly held, specifically in the context of Espinal, the very exception upon which somebody relies has to be actually invoked. And number two, the Sue decision, which the Second Department decision that the motion code invoked, contain a far more broad and all-encompassing duties with respect to the sidewalk. It required the tenant at its sole cost and expense to make foreseen, unforeseen, extraordinary, ordinary repairs, and it expressly stated that the owner is not responsible for anything. Our case contains a much more limiting general standard lease language that says maintain and repair the sidewalk. It cannot at all be compared to the sweeping obligations in Sue, and it actually falls completely in line of the case law on this issue, starting with this court's case in Collado versus Cruz, 8183rd 542, 2011 case that expressly stated on that issue that sidewalk obligations are not enough to impose the duty of care. To hold otherwise under the facts of this case and the very limiting lease obligations would completely eviscerate this body of law and render every tenant, commercial tenant under the generic lease responsible to the plaintiff.
Thank you.
Thank you very much.
Good afternoon. May it please the court. Crystal Alonzo from Callahan and Fusco on behalf of the respondents 198 Chelsea Corp. and 200 Chelsea Corp. The motion court properly denied summary judgment as several issues of fact still exist here.
Based on Mr. Sato's testimony that he only made repairs on the side of the cut that was his, his adjacent to his leasehold. Doesn't that destroy your cause and create argument and does not expose, it means that he's not exposed to liability that Shigemitsu is?
So he did state that he did fix just that sidewalk abutting the property that they leased, but that doesn't mean that they're completely absolved from liability. Just because they repaired that side of the sidewalk doesn't mean that the plaintiff didn't trip and fall there, doesn't mean that it truly is free from defect.
Trip and fall where? In other words, doesn't mean that if they tripped and fell on the other side, the meatball side, then how could Shigemitsu be liable?
Right, but we don't
On
think
a cause
it's
and
enough.
create theory.
Right, but it's not enough that Mr. Sato is just saying, we repaired the sidewalk, therefore it's free of defect, therefore we're fully absolved from any sort
No, it's not that he
liability
did the repairs, it's where, that's what I'm talking about, is where he did the repairs. So
Right.
he said he never did them in the place that's depicted in the photograph.
Correct, that is what he said.
What do you got, that's contrary to that?
Well, our argument is that, the plaintiff was showed these pictures. She generally circled, an area in the photographs that said, this is where the impression was, this is where I fell. But that alone doesn't meet the burden of
So,
it absolutely was not on our part of the sidewalk.
that's what I'm going to ask you. Do you agree with your adversary that the plaintiff testified, no, I absolutely fell on the meatball shop side of?
I don't think it's enough, maybe if they got an
Do you think she testified to
expert.
that?
What was that?
Do you think she said, no, it was in front of meatball and not in front of bakery?
I think she circled a general area. I don't think she said it was with 100% certainty in front of the meatball shop and not in front of Shigematsu. She
So
said
you
it was
think
in this
that's-
general area.
And you think that that's the question of fact, right? Because
Correct. That's
I
the
looked at
question.
those pictures too. I couldn't tell myself after looking at those.
Right, she's circling a general area, and it's a picture. It's not like she's there in person saying, this is exactly where it is. It's not like they presented expert testimony, giving us a survey, giving us boundary lines, so we could say with certainty, this is where it was, this is who was responsible.
Did that rough part, did that cover both areas, or was all the rough, bad stuff on one side?
Based
or
on the
the other?
deposition testimony that's been provided, it's either on one side or the other, but for all we know, we don't have expert evidence. It could be abutting both properties. So because we don't know, and this is a question of fact, it's too early, it's too premature to grant summary judgment here. And that's our entire argument. We don't know. We have questions of fact here, just like the motion court raised the issue, based on the language of the lease, does that fully displace the landowner from, you
Did
know,
the
any
plaintiff
duty
put
to
in-
maintain the sidewalk?
I'm sorry, I didn't mean to
ahead.
interrupt you, counsel. Did the plaintiff put in an affidavit on the summary judgment motion? I mean, we have her deposition testimony, but I didn't see one, so
There was no affidavit.
she didn't clarify one way or another,
No,
right? Okay, I just wanted to check.
no, did not.
Okay.
So, you know, that's our entire argument. You know, the standard for summary judgment is clear. Simply put, the appellant did not establish a prima facie case for, you know, the sidewalk where plaintiff fell was absolutely not abutting the property that they leased. Therefore, it's premature, and the motion court properly denied their motion for summary judgment.
Thank you.
Your Honors, I would just like to point out that plaintiff actually specifically and repeatedly identified the defect as solely appearing to one side of the expansion joint. She did it with respect to every single photograph that was marked showing the defect. She did it on pages 304, 305 in the record, again on page 312 on the record, page 304 through 307. Plaintiff was shown the photograph, expansion joint, nice sidewalk, defective sidewalk, unequivocally said on this side of the line, below the line, above the line, whatever the orientation was, she was very specific as to that.
Well, so there's an expansion joint on the photograph that's obvious. Is it obvious, though, from those photographs, whose property that expansion joint abuts?
Your Honor, yes, respectfully, it is obvious. If you look at the photographs depicted on 333 and 334, they show the sidewalk along with the building itself. So the expansion joint runs straight along the sidewalk, it goes up the building. You see, and this now with the testimony of the owner, that to the right, may I finish answering the question? Yes. Thank you. That to the right, you see a red brick building, to the left, you see a different white building, and this expansion joint runs directly between them on the building and below. And actually, the owners never disputed this argument raised by Lesser, and who, if not the owner, is in the best position to say, no, 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 this isn't the property line. They didn't submit any evidence to show that it was not. Thank you very much.
Thank you. Thank you both. People versus Anthony Griffith.
Good afternoon. My name is John Palmer, appearing on behalf of Anthony Griffith. The prosecution concedes that Mr. Griffith was incorrectly sentenced as a second violent felony offender. Accordingly, Mr. Griffith is entitled to resentencing in accordance with his true predicate status. We ask this court to vacate his sentence and remand the matter for that purpose. Of course, resentencing is the appropriate remedy here. Time and again, courts have ordered resentencing where defendants are incorrectly adjudicated predicate felons.
So your position is it's not enough that this falls within the 3.5 to 15-year period, because in the judge's mind, he was sentencing this person to a predicate violent felony, as a predicate violent felony.
Right.
Which he is not, which the people concede?
Yes.
So that he should be remanded to be sentenced again within the same range.
Yes, as he's entitled to, as this court most recently in London in July remanded for resentencing, even though the original sentence fell within the correct sentencing range. And that was also after a guilty plea. And this court has also held, as the Court of Appeals held, that such defendants, improperly adjudicated predicate felons, are entitled to resentencing, which is a completely rational, illogical remedy, as the sentencing court should make the determination on the sentence with the appropriate and proper sentencing range in mind. If the court doesn't have any other questions, I will address the questions that arise during the people's argument on rebuttal.
Sure. Thank you.
Thank you.
Good afternoon, and may it please the court. Stephen Kress on behalf of the people. The court should not remand in this case because the sentencing judge made clear that he was not willing to offer a sentence. I'm sorry. Yeah.
Does the statute require that the court consider a defendant's record when sentencing, that's an aspect for the court to consider?
Yes, absolutely, Your Honor. A defendant's criminal record is something that is considered by sentencing courts all the time.
So aren't we to assume that when the court sentenced the defendant, that the court was abiding by the statute and considering his record?
I'm sure that the judge was considering his sentencing record in the case, yes.
So the judge had before him someone who was presumed to be a second felony, violent felony offender, and in fact, you concede he was not a second violent felony offender.
That's correct. He did not meet the definition, but that doesn't change the fact that he did have prior convictions in New Jersey.
But a regular prior conviction in this state is different than a violent felony conviction. We distinguish between regular felonies and violent felonies, right?
Yes, that is correct, Your Honor. Although in this case, that doesn't change the maximum term that he could be sentenced to.
No, but we have to presume that the court was following, discharging its statutory duty, right?
I agree, Your Honor, but I think this court has on a number of occasions decided that even when a judge gets it wrong and was operating under the belief that somebody was a predicate or a predicate violent, when in fact he or she was not, that you don't need to remand every time. And what this court has said is that where the record is clear that the judge would not have imposed a different sentence, a remand is unnecessary.
How do we know the judge wouldn't have imposed a different sentence?
Well, because he says, this is on page 2 of the plea transcript, I'll give you the 12 years, but I'm not going below that.
That's right. That's within the context of his being a predicate violent felony offender.
Well, yes, it was said in that context, Your Honor, but I don't think the fact that he was a predicate would have changed anything about the
Well,
sentence.
we don't know that because the judge said, I'll give you 12 years, but they had just been speaking about his being this violent predicate. So he's thinking he's a violent predicate, I'm giving him 12 years. That's not to say if that wasn't found that he wouldn't, I mean, I'm asking this question because you said there's no way he would have given him anything else. And I don't know that statement addresses, clearly determines that.
Well, I'll say two things in response to that, Your Honor. One is that...
Say them quickly.
Yes. One is that he didn't just say it once, he said it 3 more times after that. And the second point is, I think you could say that about every case. I mean, in every case where somebody's improperly adjudicated, you could say, well, the court was operating under a mistaken...
No, sometimes the court may say, it doesn't matter to me whether you were a predicate or a violent or anything else. I'm giving you this sentence. That could have been said. Is there another question?
Yes, you know, the New York State Legislature has set out a very extensive set of sentences based upon whether someone is a predicate, a violent predicate, or a first-time offender. And we have to assume that there's a rational basis for that legislative act.
I understand that, Judge Mazzarelli, and in this case, the only difference that each of those 3 distinctions make is in the minimum sentence. It doesn't change the maximum, and the 12-year sentence that the defendant got, he could have gotten in all 3 of those contexts.
It sure does change the minimum, though, doesn't it?
It does affect the minimum, yes.
Yep.
It does. All right, thank you.
Thank you.
I would just like to note a couple of things briefly, if I may. So counsel points to other cases where this court has simply vacated the predicate finding and affirmed the sentence, but in the cases that cite in the respondent's brief, in all of those cases, the defense either, asks for an alternative remedy of just, vacating the predicate finding and reducing the sentence or something like that. But here, Mr. Griffith is asking for resentencing. And further, something that should not be ignored in this case is that this plea came down in the context of there being a risk, a threat, actually, of Mr. Griffith being a mandatory persistent violent felony offender. And on page 4 of the plea transcript, Mr. Griffith says, if you can do 12, you can do 10. And the court says, I'm not saying I'm not doing 10 for any reason, at all. It says that I'm not offering you 10. What I am doing is telling you that you will be avoiding the risk of being a persistent violent felony offender under the law. And he could not be that if this offense was not a violent predicate felon. So having said that, I ask this court to vacate Mr. Griffith's sentence and remand the case for resentencing. Thank you.
Thank you. Simmons Machine versus Skanska.
Good afternoon, Brian Quinn for the appellant. The court here erred in concluding that the contract was plain and unambiguous. The language that is at issue here is 0.005-inch accuracy.
Counselor, may I ask you something?
Yes.
When this was, when the contract was entered into, and then when the purchase agreement that had the contract terms and conditions in it, those specifications that you just were about to quote, those were within there, right? They were there from the beginning, weren't they?
The language of 0.005 inches accuracy tolerance, it was in there, but nothing was in there to explain what it meant. There was nothing in there that explained how to test for it, nothing in there to explain what the meaning was. And in this case, the court actually looked to a document that was outside the four corners of the contract. They looked at testing data that the criteria was not in the contract, no. And so you can't look to materials outside the four corners of the contract and then preclude us from putting in evidence on the party's intent or the surrounding circumstances that are present, which is what the court did here. Also, if you look at the language of the accuracy, there's nothing in there that defines if it's machine accuracy or cutting accuracy.
How much discretion was given to ACOM, the engineering firm that reviewed the two FAT tests?
Based on the case law, they don't have the discretion.
No, but in the contract,
interpret
not
the
in the case
contract.
law. I'm sorry to interrupt you, counsel, but in the contract, it says the engineer shall determine the quality, acceptability, and fitness of the work, and his determination shall be final and binding. Doesn't that put you on notice that whatever ACOM says goes?
No, Your Honor, there's lots of case law that interprets that, and it doesn't allow them to interpret the contract. That's for the court to do. And they also can't act in bad faith or just give Metro North the ability to make all these decisions. In this case, there's plenty of evidence in this record that shows that ACOM was not independent. They initially accepted the first testing results, and then Metro North is the one that rejected them. So they're not acting as some type of independent body here. Metro North actually rejected the goods at the end, not ACOM, if you look at the letter, the rejection letter. And we cited in our brief, we went through the rejection letter and showed how it's inconsistent with any type of rational or reasonable standards. Getting back to the ambiguity here, the fact that the court is relying on the materials outside the contract should have permitted Simmons to rely on the affidavit they submitted, which talks about the party's intent and the surrounding circumstances. As that indicates, this contract has never been interpreted in the manner that defendants are trying to interpret it. This is something that came from Simmons literature that they interpreted totally different, and if Metro North had a special purpose for this language, they should have disclosed that at the time of contracting, not during the testing that happened afterwards. And we submit that the court below misinterpreted the FAT results and improperly bound Simmons to the intent of the contract based on what Metro North was saying in the FAT results. Simmons was very clear, as was ACOM, after the first test results, that there were no material deviations and that the products had been accepted and comply with the specifications. That's on page 677 and 676. Also, on page 656, there's a checkbox that says the equipment complies with the specifications. And if you go to page 747, these are comments here that say the data appears to either meet or closely approach the project requirements. That's not an admission that these testing results are not being complied with or the data is deviating in any significant manner. And it goes on there to explain what some of these differentials, what might be the reason. And at the end of the day, we submit that Simmons complied with the contract and met the specifications. But if the court was to determine that there was some deviation, we ask that the court applies the holding in Jacob and Young's. Because in this case, the defects or the deviations, the alleged deviations, were 6/100ths of a human hair, which is not material in any manner. That is trivial. And we submit that the primary purpose was fulfilled because these machines did what they were supposed to do. And that's detailed in the affidavit, and that can't be refuted on a motion to dismiss.
So, counsel, let me ask you, do you dispute that you did not meet the standards that were set forth in the specification? You're supposed to have 20 consecutive things that were within the deviation. You're saying you did that?
Yes, we did meet the specifications.
Well,
Your Honor.
how come the test results said you weren't? Did you put, I don't know, how could that be? Either you did or didn't. It's not like you can fudge that. I thought your argument was that you substantially complied. You didn't actually comply, but you complied enough, right?
No, we did comply, Your Honor. We're saying we did comply.
100%?
There's a testing procedure, and they're trying to work out the kinks, and they're being told to revise and resubmit, and that's what we're doing.
Because you didn't comply,
No,
right?
Your Honor, the other side, defendants are saying we didn't comply. We're saying we complied.
Yeah, but you're saying you complied, but not with the number that was in the specifications. You just said it was the one human hair difference, whatever it was, that's not the same, right?
We're saying there's lots of other variables you would have to consider to see if that's an accurate measurement or not. And that's what they're trying to do. They're trying to figure out, is this machine capable of meeting these specifications?
So I'm just asking you, the specifications that they were set forth in the contract, you submitted some test results. Those test results didn't match those specifications, correct?
No, you cannot interpret those test results.
Okay, but the person that was charged with interpreting them that way said you didn't, correct?
No, ACOM said they passed the first round, and they said, Metro North is the one saying they didn't pass the second round.
Well, let's talk about the second round. Did they say you did the second round correctly?
We don't have that. I don't think that's in the record, ACOM's results sheet. What we have is the comments from, I believe, Metro North is in the record from the second testing result. And then we have ACOM writing a letter that says Metro North.
Well, when it says work may not proceed, revise, and resubmit, you're saying they said that even though you absolutely complied with every one of those specifications?
We're saying both sides are in disagreement over what.
Yes, I want to hear what you have to say, but first I just want you to answer me that question. Are you saying that that language, work may not proceed from ACOM, revise and resubmit, is based on ACOM's finding that you did comply?
I'm saying that it's based on ACOM or Metro North's interpretation of the contract. That's why they have that conclusion.
I'm talking about ACOM made that conclusion, right?
I don't know if ACOM made that conclusion.
Well, ACOM's engineer stated, work may not proceed, revise, and resubmit. I mean, it's in the record. Do you deny that?
There is a document in the record that's based on Metro North's interpretation of the contract.
Okay, thank you.
May it please the court, Mark Cordigiano for Respondent Skanska Echo 3JV. As the court recognizes, this is a highly sophisticated party. There are highly sophisticated parties who negotiate a very technical contract with very specific specifications that were negotiated in advance that the
Well, counsel, your opposing counsel is saying that they did meet these specifications.
Absolutely,
Just let me finish my
100%.
question.
I'm sorry.
Would you mind? That they did meet the specifications. There's just different interpretations of the specifications, and that ACOM is using an interpretation that is not proper.
They absolutely 100% did not meet the specifications. And ACOM, as the parties knew in advance and the appellant knew in advance that ACOM was going to be judging this, ACOM was going to be determining this. They had a role in setting up the test.
ACOM is the engineer for MNR, isn't that right?
ACOM is an independent company that was hired to do the review of the entire project. They were the engineer of record. They're an independent party to avoid exactly the situation of saying that one of the parties was making a decision about this. They're an international engineering firm that looked at the test that was designed by appellant. They were charged in the specs, as we point out, they were charged with coming up with the test. And they're just complaining about it afterwards because after the first test in November of 2017, they wrote a letter saying that they could not comply. They all of a sudden realized that they couldn't, and now they wanted to renegotiate the specs. This is all post hoc agreements, or post hoc changes that they want to make because they could not comply.
Sir, what about your friend's point that under, even assuming that there was some measure of non-compliance with the specs, that under Jacob and Young versus Kent, this could, any variation could be chalked up to a trivial or de minimis type?
So this is the converse of Jacobs v. Young. This is a situation where it's not the stamp on the pipe that is, it all functions the same. These were the specs that get you up to the final product. They didn't even meet the specs that get you up to the final product. And so what was done, the thing that was constructed, is not usable by Metro North. And so it's not like they have a house with plumbing with everything working. They have something that they can't use. And so it's the exact opposite. It doesn't functionally work. It didn't meet the specs. And that was what was negotiated for. So we would ask that I'm sorry, Your Honor. We would ask that
I was just going to say thank you.
Thank you, Your Honor.
Good afternoon, and may it please the court. Jennifer Mustis for respondent Metro North Railroad. Metro North seeks affirmance of the dismissal of Simmons' claims against it for breach of contract and intentional interference with contract on grounds in addition to the documentary evidence showing Simmons' own breach of its agreement with Skanska. There's no basis on which Metro North could have contractual liability to Simmons. They're not counterparties to any relevant contract, and Simmons is not a third-party beneficiary of Metro North's contract with Skanska. Furthermore, as the Court of Appeals stated in the Alvord and Swift case, there exists no tort liability to incidental beneficiaries not in privity. And even if Simmons could bring an intentional interference claim against Metro North, Metro North was justified in acting to enforce its specifications for its wheel boring machines. To the extent that a breach of contract claim is reinstated against Skanska, it's only seeking monetary damages, and Metro North would not be a necessary.
Also, what about the argument that we haven't talked about much, but that there's an allegation in the briefs anyway, that the wheels Metro North provided were rusty and that somehow threw off the tests. Are there facts specifically alleged in the complaint making that out?
There are some facts in the Healy affirmation submitted that allege an unspecified number of wheels, not specifying how many for each test were allegedly somehow rusty. But the tests proceeded nevertheless, and I think the trial court recognized that at the time of the test, there was no objection to going forward with the test with the wheels provided, and there's no allegation specific to, but for the provision of those wheels, they would have had 24 wheels that met the specifications. And in fact, all of the allegations of the Healy affidavit suggests that they think it's unnecessary, they think it's unachievable. I'd point you to page 810 of the record, where in fact it answers the question that in fact the specifications were not met. Paragraph 35 talks about the deviations from the specifications being de minimis, but obviously suggesting that the specifications were not complied with by the machines that were proffered by Simmons, and in fact there's no, but for the wheels provided, we could have complied. So unless there's any other questions, we'll rest in our submission.
Thank you.
Just very briefly on the Jacob and Young case. This case is on all fours with that case. In that case, the specification was that they must have a certain type of pipe. Here, the specification they're saying is they must have a tolerance of 0.005 inches. The issue is, did the primary purpose of the contract get fulfilled in this case? And that, we put in an affidavit that said it did. They don't have any evidence in response to that. They're just assuming because it says a specification of 0.005 that that's the primary purpose. Well, in Jacobs and Young, it said a specification of reed piping, and they didn't do reed piping, and so it wasn't about what's in the contract. It's about the primary purpose, and I think we created an issue of fact here based on the affidavit. Thank you.
Thank you. Thank you all. People versus Alex Lino.
Good afternoon again, Your Honors. May it please the court, Zoe Root on behalf of Alex Lino. Mr. Lino's crimes were very serious. And also, Mr. Lino is a disabled, mentally ill man who, before the cases encompassed in this appeal, had never before had any contact with the criminal legal system.
His crimes were committed over a span of 7 years, is that correct?
That is correct.
How was it that it finally came to light?
I'm sorry?
How was it that he was finally arrested? How did that happen?
I don't know the circumstances of his arrest. Regardless of the circumstances of Mr. Lino's arrest, if this sentence stands, he will not be released from prison until he is 67, and will not be discharged from post-release supervision until he is 87 years old. More likely, he will die under the supervision of the Department of Corrections if he is not deported first. Even accounting for the severity of the conviction charges, the aggregate 45-year sentence, the maximum on both incarceration and PRS, is excessive, particularly given his disability, age, lack of criminal record, and mental health issues.
Counsel, if he'd been convicted of the top count, it would have been a potential life sentence, correct?
That is correct.
How old was his youngest daughter when he started raping her?
I don't recall the age.
You don't?
I don't.
Because I think in the brief it talks about one girl being 6 or 8 years old when he started.
I would not contest that if that were the case.
It's your brief that I think, or the People's Brief I got that from.
Yes. In deciding the appropriateness of Mr. Lino's sentence, it is particularly important to take a moment to understand what Mr. Lino is experiencing in prison as a person who is deaf. Deaf people fare extremely poorly in prison. Advocates for incarcerated people who are deaf refer to the isolation experienced by deaf prisoners as a prison within a prison. Many deaf prisoners experience prolonged communication deprivation that leads to a lost ability to socialize or communicate with anyone in any language. In addition to the struggles that Mr. Lino is suffering because of his disability, he is even further at risk serving such an extended prison sentence because of his mental health issues. New York's correction system is ill-equipped to care for those with mental illness. There are gaps in treatment in prison staff, in the ways that prison staff respond with overly punitive measures for mentally ill individuals, exacerbating rather than improving their symptoms. And based on the fact that Mr. Lino is not only going to be under the Department of Corrections supervision for the entirety of his incarceratory sentence, but will also likely be under the stringent restrictions and registration requirements pursuant to the Sex Offender Registration Act, we are asking that Mr. Lino's incarceratory sentence be reduced from 25 years to 15 years. Thank you.
May it please the court, Amanda Regan on behalf of the people. What counsel has failed to mention both in her main brief and here at oral argument is that defendant validly waived his right to appeal, foreclosing his excessive sentence argument. And regardless, defendant's aggregate sentence of 25 years for repeatedly raping and systematically sexually abusing 4 of his daughters was entirely justified.
I think that would be all 4 of his daughters.
Yes, he got 25 years for all 4 of his daughters. He could have gotten consecutive sentences for each daughter. And as Justice Mazzarelli...
I just want to ask, is there anything in the record that indicates that he just became hearing impaired recently, or was he hearing impaired all through the time that he was committing those crimes?
He was hearing, as far as my understanding of the record is, he was hearing impaired throughout the entirety. He's been hearing impaired his entire life. And as the judge noted at sentencing, the fact that he is deaf is something that courts would generally take into consideration, but it does not explain or excuse his actions in this case. And as Justice Mazzarelli asked, one of his victims was 6 years old when the sexual abuse began. And not only did defendant engage in an escalating pattern of sexual abuse against his 4 daughters, he also psychologically tortured them into silence by threatening to kill them if they told anybody about his abuse. So these 4 girls, unbeknownst to one another, were all being raped in the exact same way. And all of defendants...
Was this all going on in one apartment? Were there other people there?
I believe so. I believe there were other children in the apartment and either a common law spouse or a legal spouse. But many of the current claims that defendant is raising as reasons why this court should lower his sentence are completely unfounded in the record. There's no indication at all that the defendant has any mental health issues, and there was no indication below, and defense counsel has pointed out on appeal to no diagnoses or treatment that he's receiving. The defendant's 4 victims, his daughters, they're entitled to closure, the closure that defendant's sentence brings. And on that basis, we would ask that this court uphold defendant's sentence.
So just to start with the point about the appeal waiver in this case was not valid. Mr. Lino did not validly waive his right to appeal. The court's oral review of the appeal waiver failed to adequately inform Mr. Lino of the rights he was giving up. First, the court failed to make clear to Mr. Lino that the waiver was not automatic upon his particular guilty plea. Second, the court did not mention that, unlike other rights he waived that day, his right to appeal would survive a guilty plea. Third, the court also misinformed Mr. Lino about the nature of the rights that he was forfeiting. To address the people's point about the proof in the record of Mr. Lino's mental health issues, there is proof of his mental health issues in the record. In a 2018 letter to the court, which is in the court file, Mr. Lino's defense attorney brought to the court's attention, quote, the existence of seemingly significant psychiatric issues. And the defense attorney also indicated that she believed that Mr. Lino was exhibiting signs of mental illness, and it would seem, quote, that he was experiencing some sort of break with reality. In addition, to address again the shared understanding that the charges in this case are incredibly serious. This court has reduced sentences in other serious cases. The fact that the charges in this case are serious do not mandate that his sentence stand, given the fact of his age, his mental illness, his status as a disabled person.
Wait a second. When you say mental illness, you're saying that you're basing that on a letter from a lawyer. There's no psychological evaluation, correct?
No, there was no psychological
There's no
evaluation.
indication that he ever took any medication for mental illness. So all your mental illness argument is based entirely on one letter from a lawyer, correct?
Yes, a letter written by an officer of the court to the court.
I'm a lawyer, you're a lawyer, we're not psychiatrists, right? We don't prescribe medication, we don't make diagnoses.
No, but the attorney who was charged with providing Mr. Lino his defense attorney, his legal defense had in her assessment determined that she believed that Mr. Lino was experiencing what she believed was in break with reality.
Thank you.
Thank you.
Thank you both. Drame or Drame versus 6050 Bushwick Realty.
Good afternoon, Your Honors. May it please the Court. Brian Isaac, I represent the plaintiff appellant in this matter. Our position is that there is no smoking gun evidence here. We're not saying that the lawyers who papered over the lease and sale deal didn't do it the right way. What we're saying is that when you look at the totality of the evidence, the grant of summary judgment on this record was inappropriate because certain things just don't add up regarding complete divestiture of possession and control. And the case that we're relying on is a decision dealing with multiple dwelling law, Article 78, but it's a full opinion by a former member of this court, Bonifacio. It's Bonifacio against 910-30 South Boulevard. It's at 295 AD 2nd 86 at 91. And the court there said, one sentence, quote, "Its true position regarding the operations of the building is called into question by the unexplained connections among the former owner, the current owner, and the agent/lessee." Now, none of the points that we raised here below, standing alone, might be sufficient to forestall summary judgment. But if you look at this case, I think there are 2 or 3 factors that are very important. The most important of which is the testimony of Mr. Leal to the effect that he was at the premises 1 to 2 times a year to wash his car. Now, why is that important? Well, it contradicts the plaintiff's testimony that he was there with a degree of regularity. When you read the defendant's beautifully written briefs, they concede that he testified to that effect. And the real issue here is there's no reason for him to be there unless he's exercising some ownership function. Why?
Why is that the case, Mr. Isaacs, really? I mean, he could be visiting, well, his daughter-in-law, his biological daughter was not that involved in the business, so maybe he wasn't visiting her, but, you know, his son-in-law, he could have been there for numerous reasons.
Well, I'll tell you why, Judge Moulton, and it's on 373 to 375 of the record, okay? First, he said on 373 that he walked away from the business, wanted nothing to do with it, and left all decisions to his daughter and son-in-law. He also said that they didn't discuss business. That's on 373 of the record. He also said, and this is on 375, perhaps the key phrase, he said that he does not go to the car wash to see Regina and her husband. So if he says...
But didn't he say that he's sometimes there because he picks up he's checking on the other building that's adjacent?
He did.
So why couldn't he just be going to the car wash?
Because his testimony was, even with respect to that, Judge Renwick, I think it's on 375 of the record, that he did that at most, okay, 6 times a year. There's not that degree of regularity that's present. The other thing in the case is that...
Counsel, other than him being physically in the building, is there any testimony from anyone that he made any decisions about the car wash or the panel that was over? Is there any testimony?
There's no...
So he's physically in the building, but other than that, there's nothing.
Right, there's no... that's why I was careful to say, Judge Capullo, there's no smoking gun admission, Perry Mason...
There's no nothing. Not only is other than the fact that a principal of the corporate defendant is in the building, there's no testimony that that corporation or had anything to do with running the car wash.
That's true, but he also testified, as you know from reading my brief, that if he saw a condition that was defective, he would report it. And the plaintiff, who is not a sophisticated person at all, actually was able to distinguish between what he defined, this is on 335 to 341, between an owner, which referred to Mr. Leal, and to bosses, which referred to the managers who were at the premises. So I'm not suggesting to you that any one of these things standing alone is dispositive, but I would point out to you one fact, and I just ask you to consider it. If you look at our brief and you look at our reply brief, there are 2 really, really big footnotes dealing with summary judgment motions, credibility, where defendants have exclusive knowledge of the facts. It goes back to, as you know, Carl against Cohen. It's a 3rd Department case, but you've decided the same thing in the Parcelano against County of Nassau case. Courts have said that in those situations, summary judgment motions should not be decided, quote, based on affidavits. And I would suggest to you that if you look at the briefs, they controvert everything we say, but they don't deal with that issue. And I think that is the key here, because it's very hard for a plaintiff to prove a negative on an issue where he can't have any affirmative proof, which is the situation here.
One piece of documentary evidence that you talk about a bit is the power of attorney given to the daughter. And I wonder, can you draw a negative inference, negative to you, the plaintiff? Because one thing that's not checked as one of the powers is, it's very small type, but it says business operating transactions, and that's excluded. That's not part of the power. So should we draw an inference that if he was going to be involved with the business, he would have checked that box.
Judge Remick, my answer, Judge Moulton-Kesson? The answer is no, and I'll tell you why. Because Mr. Leal also said that notwithstanding the box that he checked with respect to banking, that his daughter Regina did not have the authority to write checks. So his testimony on that is inconsistent. And the issue there isn't what box he checked. The overall issue here from our perspective is the issue of control. Was it negated as a matter of law? Sorry for going over my time.
Good afternoon, Your Honors. May it please the Court, Stacy Malino for Respondent 1650 Bushwick Realty Corp. I wanted to highlight for this Court that with respect to my client 1650 Bushwick Realty Corp, they are even more than one step away from the lack of control that you would normally see in an out-of-possession landlord case. Because in this case, 1650 Bushwick Realty Corp never even owned the car wash, never operated the car wash. The car wash was owned, operated, and built by non-party defendant Bushwick Car Wash. And the car wash was then sold from, along with the conveyor, from Bushwick Car Wash to third-party defendant SLS Car Wash, who then replaced the conveyor twice before the accident and was in the process of replacing the cover that was missing at the time of the accident. Counsel for appellant even concedes in their brief that SLS owned and operated the car wash. And with respect to a couple of points brought during oral argument about that Mr. Leal was there more frequently based on plaintiff's testimony than he testified to, even assuming those facts in the light most favorable to the opponent. As Your Honor highlighted, there's still no evidence that he did anything when he was there. And as Your Honor also pointed out, when he was there, he said he went there specifically to deal with the tenant next door and to get rent checks. And when he was there, he just happened to get a car wash. He was only in New York 3 months a year. He was not at the car wash with any regularity, as plaintiff claims. But again, even if he was, it still doesn't rise to the level of control. And with regards to the power of attorney that Your Honor asked about, even if, as counsel says, that there could potentially be some testimony by Regina Santos that she exercised powers in addition to those granted to her by the power of attorney, she could not have. Pursuant to the lease, the ability to perform non-structural repairs, as even acknowledged in appellant's brief, fell squarely on SLS Car Wash. So Regina Santos did not have the power pursuant to the lease or pursuant to the power of attorney to perform non-structural repairs of this car wash where the plaintiff was injured. And my last quick point is with regards to the argument of exclusive knowledge. In counsel's brief, it talks about that this exclusive knowledge is within the family of the defendants. 2 of those members of that family were deposed. Fernando Leal and Vladimir Santos, the husband of Regina Santos, were both deposed. Both testified she had nothing to do with the business. Mr. Santos testified that his wife worked for the school district. She was never there. 2 other employees of SLS also testified, one of whom worked there for 25 years. They didn't even know who she was. All of that evidence contradicts any potential evidence that appellant hopes to get from Ms. Santos that she operated the car wash. There's clearly no evidence to support a fishing expedition of a deposition of her that will not amount to any evidence to contradict the record herein. Thank you.
Thank you.
So I will be brief. The distinction that counsel drew between the car wash operator and 1650 is one that's illusory. If you look at 503 of the record, Bushwick Car Wash, Inc. is controlled by Fernando Leal. It's the same entity, it's the same person controlling both entities. Secondly, I thought I heard my adversaries say that the tenant was not allowed to make non-structural repairs. I don't think that's accurate. I think if you look at 510, paragraph 6, maintenance and repair, they were supposed to make structural repairs. And Judge Moulton, I'm sorry, I didn't have time to get to it, but I don't think it was Ms. Malino. I think it was SLS who took the position that any repair that was made at the end of the lease to the conveyor belt would have not been within the terms of the demised lease based on the definition of lessee's equipment. And I would suggest to you that if you look at 540 of the record, the third paragraph, they've misread that. The lessee's equipment would be anything that could be removed without adversely affecting the premises. And the words that they use, provided they are, quote, not used and are not procured for use in whole or in part in connection with the operation, maintenance, or protection of the demised premises. This was a car wash. That conveyor was going back to the owner at the end of the lease as a matter of law and as a matter of fact. Thanks for listening to me.
Maltese versus Port Authority.
Good afternoon. May it please the court, Daniel Rosenberg for Appellant. It is respectfully submitted that the trial court erred in granting summary judgment to plaintiff on their claim for violation of labor law 240, subsection
Counsel,
1.
the plaintiff was on a ladder. Was there a safety device provided to him for that ladder?
So there are multiple witnesses that have testified and provided sworn affidavits that there were alternative safety devices present at the job site at the time of the incident. There is testimony that there were scaffolding kept
But the
in
scaffolding
boxes.
was in a gang box or something in a train somewhere. And I don't know, I thought someone testified that one of his coworkers, the area was narrow or small. So not clear that any such scaffold would have worked there.
So there, in addition to the scaffolding that that witnesses had testified was present, there were alternative means to use as a safety device, such as a boom lift and a man lift.
Again, those lifts require a base. There's a base. Where's the base going to go if there's no room for a scaffold? How are you going to have how would you have room for such a base, a boom lift or a man lift?
So I wasn't present at the job site, and there is no testimony as to whether the boom lift, man lift would have fit in the area where the plaintiff was working at the time of the incident. But there is testimony that there were proper protective devices that were present, and for the
Counsel,
plaintiff to.
in the Court of Appeals' recent decision in Bianca Netto, it doesn't that hold that availability of a safety device is not enough? It also there have to be instructions to use it.
So
is there evidence of instructions here?
There's testimony in the record that there were instructions that were provided daily as to the proper protective equipment that was supposed to be used while working at the job site, and taking into consideration that the plaintiff was certified in OSHA training and was a union member for carpentry since 1998. He had amassed the skill and competency to use the adequate safety devices that were present at the job site, and which were included in the daily safety talks pre-work.
So, counsel, you're saying that there were scaffolds. They weren't set up, right?
The scaffolding was not set up at the
So
time
there's
of the incident.
somewhere in that building, there's a scaffold.
There
And
were scaffoldings
somewhere
in the gang box.
building, there's a boom, but there's no tie-offs, right?
I'm sorry, there was,
There are no place to tie off,
no, the plaintiff was going to be setting up tie-off points at the time.
but he couldn't tie off going up, correct?
He was unable to tie off at the time of the incident.
And the coworker submits an affidavit saying there weren't any scaffolds set up in that area. It wasn't like, you know, here's the safety device that you should use. And the plaintiff, you're saying that the plaintiff had the obligation to go into some place else in the building, find the scaffolding, assuming that he even knew that it was going to be there that day, and bring it back and set it up himself?
The scaffolding, he wouldn't have to have set up the scaffolding himself. He had other workers, and the testimony from his coworker had indicated that the scaffolding was nearby. He also opted to use the ladder without anybody securing it before he scaled it.
Thank you.
May it please the court, Your Honors. My name is Scott Singer. I represent the plaintiff's respondents. As to the scaffolding, the testimony was provided by Mr. Abidjan at page 637. And he mentioned, apparently as a reference to a document, although it doesn't seem to be in the record, it says the contractor installed scaffolds on the platform. Mr. Abidjan answers, that is correct. That information, where did it come from, sir? And Mr. Abidjan said, this is my observation on the welders, this platform. So, I mean, that's the sum total of evidence.
Was plaintiff ever instructed to use a scaffold?
No, he was never, there's no evidence that he was instructed about anything pertaining to any safety devices. And as you pointed out, Justice Scarpolo, the testimony was that it wasn't clear that he could have used the man lift in that location. There were no safety devices installed for his use. He was never instructed he couldn't use the ladder. So there was a prima facie case that Labor Law 240 was violated because the ladder collapsed. There was no indication that the criteria for proving sole proximate cause were established by the evidence.
Sir, what about the suggestion that there was equipment in various places throughout the worksite that could have been employed?
Well, Judge, from, you know, something somewhere at the job site, that just doesn't do it. There was a
Well, they specifically said it was in the gang box in the train.
well, there's no indication of what was in the gang box in the train. There was a statement that there was some equipment somewhere in the gang box, you know, that they could have run on the tracks. But there was no indication that scaffolding or man lifts or anything else was in that gang box, or equipment that it could have been used to install a tie-off point. So, and there was no evidence at all that he was instructed to take certain measures other than what he did. He was using a ladder that was already at the job site. It was an entirely appropriate procedure and action on his part. And in the absence of any proof that he disregarded instruction or that there was readily available equipment as specified by the testimony, not by, there was a generic statement, oh, everything was readily available, but there was no specific testimony that where that was or how easy it was to get it. That's not enough to raise an issue of fact, Your Honor. So we ask that the order be affirmed.
Thank you.
Thank you.
I'll keep this brief. There are, in addition to his coworker, there are 2 witnesses in total that testified that there was scaffolding used at the specific job site and that the plaintiff was made aware
There was
of the
scaffolding at the job site, but not at that location. It was not, I mean, they were working in an extensive area. There was nothing that said it was at that particular location.
There is testimony that the gang boxes that contained the scaffolding were nearby, and respectfully,
No. What I'm saying is that there was testimony that scaffolding was being used in other areas, but not that it was being used in that area. And his coworkers testified that they, in that group or that gang, I think they said, would have used the same thing that he used. So it was the belief of those fellow coworkers that that was what he was using was what should have been used for that area in which they were working.
So his coworker actually testified that he would have used the scaffolding that was provided, that was present at the job site, and that the plaintiff should have known the exact same information that he would have employed. Further, the proponent for a summary judgment has to establish that there are no tribal issues of fact, and here.
So, counsel, when you say you have established an issue of fact with respect to a recalcitrant worker, right? You have to show that he was told to use something and chose not to do it. Is there any testimony that he was told to get up and tie off on the top? You must have someone hold the ladder, or you must use scaffolding. Was he told that? Did anyone testify that he was specifically told that?
There's no testimony that he was
How
told
could
to.
you have established that part of the recalcitrant worker defense?
I think before we even get to the part of him being a recalcitrant worker, there's questions of fact that exist as to the proper devices that were first made readily available before he is able to even disregard.
Wait, but do we not agree that there was a ladder, it slipped and he fell, right? That's a 241. So he's made out his case. There's a ladder, it wasn't tied off and he fell. But I thought your argument was sole proximate cause or recalcitrant worker, however you want to put it. Isn't that your argument?
So the argument, I will agree that the plaintiff was on a ladder and it slipped at the time. One of the arguments made by plaintiff and that is relied upon in the trial court's order is that the ladder was deemed defective. And it was deemed defective because of a missing footing that was found after the incident. There's no proof as to when this ladder was missing this footing or it was a product of the plaintiff's fall. So the defendant's position is that there are questions of fact that there should be determined by a jury.
Just to be clear,
availability.
Sorry, go ahead.
So sorry, as to the availability of the alternative safety devices, there is testimony in the record as to the toolbox talks and the instructions.
There is also, I think, when I said that there was a coworker who said that he was doing what everybody else said, I think you said no, that the coworker said that these things were available.
Yes.
And the coworker was Jeff Cohill, and he says that Tony was doing what any of us in the gang would have been doing at the time of the accident, which was setting up the ladder. Tony was tying off the ladder to try to make it safe when the accident occurred. There were no other ladders in that area at the time of the accident when the accident occurred. There was certainly no scaffold set up in that area either.
And in direct contradiction, there's another coworker, Gifford Cross.
Okay, you didn't say another coworker. You said
Gifford Cross is Gifford Cross is another coworker of the plaintiff that had provided a statement to the contrary, that there were scaffolding. And as such, the defendants...
scaffolding in the area. Thank you. Thank you both.
Thank you.
People versus DeCourcy Bell.
Good afternoon, Your Honors. Cami Lizarraga from the Office of the Appellate Defender on behalf of DeCourcy Bell. In these cases, the minimum sentence available to Mr. Bell was doubled from 3.5 to 7 years based on an out-of-state conviction, namely Mr. Bell's Massachusetts firearm offenses. Both parties agree that the Massachusetts and New York definitions of firearm are textually different. So the prosecution, as the party seeking additional punishment in this case, bears the burden to show that those definitions nonetheless are strictly equivalent, which is the standard under New York law. Because it failed to carry that burden before the post-conviction court below, the conviction cannot serve as a predicate. And I would like to start with the default rule here, Your Honor, which is that a person like Mr. Bell, who has no prior New York felony conviction, is a first felony offender. There's no presumption that an out-of-state conviction can be used as a predicate. In order for it to be used as a predicate, the prosecution must show it's exactly the same.
We're allowed to look at case law interpreting a state's statute, correct?
Certainly you are, Your Honor.
And so, well, then that, of course, begs the question about Commonwealth versus Rhodes, which held that a BB gun is not possession of a firearm under the relevant Massachusetts law.
Well, first of all, Your Honor, Rhodes gets to the example of BB guns and air rifles, not the broader question of the strict equivalence of these two definitions overall, both of which I would like to address. Because as a threshold matter, the prosecution, when faced with these two different definitions, had to show that Massachusetts' broad catch-all provision captured only the 5 categories of weapons in New York's definition. It did not even attempt to make that showing below, Your Honor, which is a threshold error that means they did not meet their burden here. And Helms show how the burden works in this context. Helms is a Court of Appeals case we cite in our papers. In Helms, the defendant objected to the use of an out-of-state conviction because the statute on its face was different. That's the only thing the defendant has to do is object and say, look, the statute on its face is different. The prosecution then came forward and mustered Georgia statutes and case law that established concretely that the statutes nonetheless were exactly the same. And that's what's missing here, is that before the 440 court, the prosecution never made the argument that it tries to now make on appeal, that the two definitions are functionally identical overall.
But isn't it clear from the argument that the BB guns and the air rifles aren't firearms under the Massachusetts 10A and N, and that the 12B is what exclusively categorizes and regulates BB guns?
With respect to that example, no. The Massachusetts law in 2006 did not eliminate the possibility that a minor could be convicted under 10A for possessing a BB gun or air rifle. Because when Rhodes and the Massachusetts cases said that 12B was the exclusive regulation, what it was assessing was whether an adult complied with 12B. That's the exception under 10A for culpability if you possess a BB gun or air rifle. And notably, 10A explicitly referred to a BB gun or air rifle as within the scope of the statute. But a person is accepted if they comply with 12B. And those courts set the issue.
Yeah, but then back to what my colleague said about Rhodes, I think Rhodes was the one where the a conviction was reversed. Is that?
Exactly, because they held that an adult complies with 12B. Because even though 12B is silent as to adults, it's intended to be the exclusive regulation on possession in a public place, which is what it regulates. It only spoke to minors, and they said, no, an adult complies with this. The issue is a minor would not comply with 12B, and no case before 2006 involved a minor or ruled out that possibility. And the standard for strict equivalency is that even the smallest distinction, even technical distinctions suffice if it is possible for anyone to be convicted of something that would not be a crime in New York. The predicate cannot be used. And notably, Mr. Bell was a minor at the time of his predicate conviction here. So where none of the Massachusetts cases actually addressed a minor, there was doubt here as to how the law would turn out, which was not resolved until 2015, after Mr. Bell's conviction, when Massachusetts finally said for the first time, these are not firearms. Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people.
So, counsel, I'd like to start where co-counsel left off, not co-counsel, opposing counsel. So this defendant was a minor at the time, and what she says is that the BB gun section says that it's not lawful for a minor to have a BB gun. It says that it is lawful if you're an adult or if you're a minor with an adult. And he's charged with a firearm. So why wouldn't he potentially have been included in that if he was a minor with a BB gun, since that seems to be criminal activity?
Well, Your Honor, as Your Honor noted, we are allowed to look at the case law in this situation, and Commonwealth v.
But
Fenton.
that one speaks to an adult. as
Well,
counsel
Commonwealth
said.
v. Fenton explicitly holds that possession of any, this is a quote from that case, possession of any type of air gun by either an adult or a minor is regulated exclusively by Section 12B, which is the statute pertaining to air guns. And so the wealth of case law coming out of Massachusetts has always decided against this argument that somehow a BB gun is a firearm. It has looked at it in a slightly different lens. It's true that Garrett was the only case that explicitly said under the definition a BB gun is not a firearm, but all the other cases preceding that, which were all pre-2006 cases, have said that Section 12B is the exclusive regulatory framework for possession of BB guns.
But when was the defendant convicted in Massachusetts of this offense?
2006, Your Honor. And so,
So
the
that's before Garrett, as she said, in 2015, right?
The Garrett case is from 2015, but of course the statute hadn't changed at all since that time, and that's really just interpretation of that.
the case law that clarifies the statute.
That's correct, Your Honor.
And Rhodes clarifies the statute with regard to adults. But where's the case law that clarifies the statute with regard to minors?
Your Honor, I would point again to Fenton, which explicitly says that possession of any type of air gun by either an adult or a minor is regulated exclusively by Section 12B. And that case is from 1985. The only case that defendant cites is an intermediate level court decision from 1982, which precedes all of these Massachusetts Supreme Court cases that have gone the other way. There's simply no way to reconcile the 4 or 5 cases that have come from the Massachusetts Supreme Court with Ameren, the case cited in defense brief, to conclude that a BB gun is the same as a firearm. And as a general policy matter, that makes perfect sense. If a BB gun or an air gun were regulated the same way as a firearm, minors would be required to have licenses for them. They would be required to have serial numbers on their BB guns, and they would be subjected to very harsh punishments, which the Garrett court said there's simply no reason to read that into the statute. And so what this all comes down to is that the defense does not dispute that all of the elements of the Massachusetts statutes actually match perfectly to Penal Law Section 265.03 sub 3, and instead is just relying on this firearm definition, but they haven't set forth any concrete examples of how those two are different. Of course, they are textually different, but we would submit that based on the case law discussing the BB gun exception and just even the plain language of 10A, which is the Massachusetts statute, is limited even in its definition of any other weapon. It still limits itself by saying that the weapon must fire a shot or a bullet, which the statute distinguishes in other places from BB ammunition, which it describes as a pellet or a BB shot. And so under 10A, it still has to be a shot, like from a shotgun or from a bullet. It must be under a certain length. It must be constructed in a shape that resembles a gun, and it must be detectable by an X-ray machine or a metal detector. And so based on the plain language and the case law, we would simply submit that the people more than carried their burden before the 440 court to show that these are strictly equivalent, which was the entire focus of that court's decision, and that decision should be affirmed.
Thank you.
Thank you very much.
Your Honor, just a few points. My adversary's interpretation of Rhodes and Fenton's exclusive language was directly rejected by the Massachusetts court itself in Sayers. Sayers held that the reference to 12B being the exclusive regulation didn't mean that you couldn't be prosecuted under a different statute. And I'd like to actually read those 2 sentences. The defendants in this case argue that because we said in Rhodes and Fenton that 12B is the exclusive regulatory language governing BB gun possession, their compliance with 12B insulates them from any criminal liability under 10J, which is a different statute. We disagree. That's not what they meant. What they meant was that in assessing whether an adult complies with 12B for purposes of 10A, they were looking to whether 12B's silence on adults meant adults didn't comply. But they said, no, 12B was intended to be the exclusive regulation on this topic, so adults do comply, even though they're not mentioned. It didn't mean that people couldn't be prosecuted under other provisions. And the bottom line is, the case law didn't eliminate doubt, where the statute...
Counsel, what about your opponent's point that youth, people under the age of 18, don't have to get licenses for BB guns, and there are all the other requirements, they don't have to get a permit? What about that point?
Those are good policy arguments, but that's not the inquiry for this court. This court's inquiry is whether it was possible under the Massachusetts statute in 2006 for someone to be convicted of conduct that wasn't a felony. And the statute here, 10A, explicitly referred to air rifles and BB guns as within its scope. It said you cannot knowingly possess a firearm unless, and one exception was, as to possession of an air rifle or BB gun, you comply with 12B. That contemplates those weapons as within the scope on the face. And there was no decision until 2015 saying conclusively they are not firearms. Thank you, Your Honor.
Thank you. Thank you both. Stewart versus Woolman Rink.
Good afternoon, if it may please the court. Mark Walsh, Rosenbaum on behalf of Roderick Stewart, the appellant. This appeal is taken because the lower court erred in granting the defendant's summary judgment, finding that the evidence contained in the record sufficient to establish a lack of constructive or actual notice. Particularly, the lower court relied on a very particular case and precedent set by this court in the matter of Love v. City of New York. That case was one that basically allowed the courts to accept deposition testimony, affirming that a party followed a particular piece of scheduling submitted in evidence as sufficient to establish that it actually was followed without independent recollection of the date in question. That case, the progeny of that case, since it was decided in 2011, has been cited 13 times by this court, 12 of which it was used to affirm decisions granting defendant summary judgment. All 12 of those times was with the same defendant, New York City Housing Authority. New York City Housing Authority in those cases and the records contained therein all established the particulars of the evidence necessary to invoke that particular precedent. That bar of admissible evidence is not here. As a result, the one case that distinguishes the scope and narrows the scope, an application of Love in Gautier, is more applicable here, and for that reason the court erred in granting summary judgment. The defendant witness that appeared for deposition had no independent recollection of what he had performed that day. He had no independent recollection of how many times he had inspected the condition of the ice skating rink, and he had affirmed...
So wait a second, counsel. Are you saying that 10 years after the fact or 6 years after the fact, if I have records that say to me I did this at this time, that I can't rely on those records because I can't remember 6 years later that on Tuesday at 3 o'clock I swept the stairs, or I used the Zamboni, or whatever. In this case, I guess it's use the Zamboni. You're saying that's not sufficient. You're expecting independent recollection from every witness about something that they did years earlier?
Not at all, Your Honor.
So then maybe I'm misunderstanding. What are you saying then?
I'm saying in absence of there being physical admissible evidence of the particulars of the events that were performed on that day as far as inspections and maintenance of the ice rink, then absent that, where someone could look at that and say, that is my daily schedule set in stone, and I would have done that on that day as any other day.
Wasn't Mr. Miliano shown the Zamboni logbook? I mean, and he could qualify it? I mean, why wasn't the Zamboni logbook enough to show that the Zamboni swept it for?
So Miliano didn't perform the activities in the Zamboni logbook.
Right.
So when he looked at it, he simply would say, this is a Zamboni logbook. Further, his own deposition testimony, affirmatively, when asked multiple times and contained in the record, establishes when specifically asked, are there any records kept or made at the time that would establish when inspections were performed, to which he affirmed there were not. When
Well,
asked
the
if they were-
inspections is one thing, dry cuts with the Zamboni is another. The Zamboni logbook says there was a dry cut that day at 4 o'clock, right?
Sure. To that point, however, Mr. Stewart actually testified clearly at the time of his deposition that he arrived at the ice skating rink at 3:45. He immediately approached his superiors to ask if they were going to have hockey practice on the ice with the kids because it was in a dangerous condition and he feared for their safety. He was told, yes, we have to go forward with it. He then testified that shortly after 4 o'clock, he entered the ice, and at the time it remained in the same rough condition, and he never observed a Zamboni enter the ice, and he remained on the ice from when he entered at 4 o'clock until he subsequently fell sometime thereafter, having never seen a Zamboni. So there's an inherent issue of fact there.
Also, didn't he position the practice in a particular part of the rink where he thought he was mitigating the rough ice?
He tried to, yes. Before the practice, he said he testified he skated around because the ice was so rough, tried to cordon off the areas that were dangerous, and picked the area he thought best. But unfortunately for Mr. Stewart, the reason why I'm here today is because he didn't observe the particular defect that caused his accident.
The Zambonis are pretty big and loud, aren't they?
Yeah, you wouldn't be able to miss it, Your Honor, if you were on the same ice rink as a Zamboni driver. So to that point, the court didn't credit Mr. Stewart's testimony that inherently creates an issue of fact. And by granting summary judgment without even a discussion of his testimony, I can't say for certain whether it was considered, overlooked, or whether the judge improperly exceeded their scope in making a determination as to the credibility of Mr. Stewart's testimony, inasmuch as on summary judgment, it is the court's.
Well, sir, notice is one thing. What about assumption of risk? Right? Because there are two separate defenses here, potential defenses. One would be lack of notice. The other is the assumption of risk, primary assumption of risk.
Sure. The assumption of risk needs to be addressed in as much as it was raised by the respondent. It wasn't decided on by the lower court or addressed in their decision. The assumption of risk doctrine has its own defense there too. There's a defense to the defense, and that is the inherent compulsion. The inherent compulsion defense basically says that an individual has to have freely assumed the risk for an assumption of risk doctrine to apply. Mr. Stewart actually testified that prior to hockey practice, he expressed concern about going onto the ice and conducting hockey practice.
Express concern to whom?
To his directors, the defendants at Woolman Rink, who were the ones in charge and assigning him to hockey practice. He said, are we sending the kids out there? It's dangerous, or the ice is in bad condition, to which he was told, yes, we are. You have to go out there. The kids wear full gear and pads and they fall all the time. They'll be fine. So he was told he had to go forward with practice. If I may finish, he was then asked specifically as deposition if he had any authority himself to independently cancel or postpone this hockey practice, to which he answered he did not. That authority solely remained with the defendants who instructed him he had to do it. So based on this inherent compulsion, the assumption of risk doctrine does not apply to the instant facts of this case.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is John Sandercock, and I represent the defendants.
I think you're going to have to keep your mic right in front of your mouth. Yeah.
All right.
Speak right into it.
Okay. Well, Your Honors, the motion court correctly granted the rink's motion for summary judgment because the defendants did not have notice of the rut in the ice that allegedly caused Mr. Stewart to fall. His complaint was that the ice was rough, and he then explained that at his deposition by meaning, at his deposition, he explained that what he meant was that it was warm and that ice is better when it is cold. He did not bring to the attention of the defendant's managers any particular condition on the ice, and a general awareness of a dangerous condition is not proof of constructive notice of the actual.
He was about to lead a hockey practice of junior high students, right?
Yes.
And so he's going to them and saying that the ice is rough. I mean, does that cause red flags to go up or not?
No, I don't think so. They have practice over the entire season. Some days the ice will be in better condition than others.
Well, but he was a regular coach there, right? So normally, wouldn't he just go forward with a practice? He wouldn't complain about the ice unless there was something to complain about, or not?
He was a first-time coach that year. I don't know how comfortable he would have been raising those issues.
Well, he was comfortable that day, so one would assume that he was comfortable the rest of the time, but he didn't see anything.
Well, that is true.
Or he
But
was,
he was in control of the practice. He chose, where to engage in it, and in fact, he was injured while he was demonstrating a drill, a completely voluntary, action that he was in charge of. He decided where to do it, and
sir, does that cut in favor of the party opposing summary judgment here? Because the coach testified that he chose the area, and I think Judge Moulton touched on this. He chose the area he chose because he was concerned about the condition of the ice elsewhere.
well, he knew generally where it was safe for the boys and girls to practice. I guess I'm saying that he chose to perform this drill, which it involves some fairly tricky skating, and he fell. That's assumption of the risk. And as far as his argument concerning coercion is concerned, he was an employee of the school, not the Lasker rink. And
Is there an issue of fact as to whether, or is there an ambiguity as to who was employing him, or whether he was operating as an independent contractor?
He was acting as an independent contractor, but he pled in his bill of lading that he was an independent contractor of the Berthwaite School, and they paid him. He was not an employee of the Lasker rink, and certainly his employment was not at risk by his raising the issue. And the case, the Verducci case, which plaintiff cites in his brief, was decided in 1960.
Thank you.
Thank you.
Just briefly to address 2 points, if I may, Your Honors. When it was questioned about how he described the ice, and he said that the ice was in rough condition, he described the ice as soft. He described that ideally you would want ice to be hard and flat, and that soft ice would thus be unflat. The duty imposed, the constructive notice imposed upon the defendants arose at the time that he went to them and addressed the fact that we're about to have children on the ice, and he raised concerns that it was unsafe to do so. This was after his own clear observations. To the extent that the defendants now, or respondents now, wish to argue that he had volunteered to perform this drill, and at the precise moment he had got injured performing the drill, he was voluntarily doing so. He was not voluntarily doing so. He didn't want to go forward with practice. He didn't want to coach. He thought it was unsafe and the ice was not fit for that. Respondents would have you believe that he was supposed to verbalize the drill or display it. The way that he had to coach was by conducting drills and showing drills. It's a visual type of training. To the last part, the issue of whether or not he was an employee, the testimony is clear. An inherent compulsion requires that the person subject to the inherent compulsion believe that they were being compelled based on this. His testimony was that he was offered the job by the directors for Woolman Rinks. He met with the director of Woolman Rink to discuss it. He never met with an individual from the school. He was told that he had no authority to cancel the practice and that authority rested with Woolman Rink. Everything points to the fact that he had no reasonable basis to believe he was not working for anyone by Woolman Rink. And the matter is so confusing, I would have you look to respondent's brief, in which therein he states in his counterstatement of facts that he was a hockey coach employed by Woolman Rink. The issue of whether or not he was inherently compelled based on his understanding of his position is one that is so muddied that there's a clear issue of fact, the assumption of risk.
Thank you. Thank you both.
Thank you.
Tradesman Program versus Doyle.
Good afternoon, Your Honors. Laura Longobardi, Philip Snizer, for the defendants' appellants. May it please the court, this is a case where the underlying appeal is based on multiple orders and multiple motions. I'm only going to be addressing one of those motions, specifically motion number 2, which was the plaintiff's motion for summary judgment. And as far as the rest of the appeal, will rely on the papers. It is the defendant's position that the court below erroneously granted summary judgment on the plaintiff's declaratory judgment action, seeking to declare that they had a right to terminate member JCB for cause based on a prior felony conviction of the member.
Mr. Doyle, I'm sorry to interrupt you, counsel.
That's right.
Mr. Doyle formed JCB, right?
Correct.
Were there any other officers or any other members?
No.
He was it. So
He was
he was
it.
the equivalent of JCB, you would say?
Correct.
Okay, thanks.
Okay. He had a prior felony conviction, which he had apprised the other members of tradesmen at the time he was being brought in. One of the other members, in fact, admitted this in his deposition testimony. We believe that the court erroneously granted summary judgment because she, as a matter of law, misinterpreted the definition of cause in the operating agreement, and 2, instead of determining whether there were material facts in dispute with respect to Mr. Doyle's conviction and with respect to the transfers, she, in fact, resolved those issues in the favor of defendant.
How about the other possible cause finding, which would be based on the lack of relationship between the Doherty entities and JCB? Let me ask the question. Were the plaintiffs ever given any evidence of the requisite relationship between the Doherty entities and JCP?
I'm not sure I understood. I didn't quite hear your question.
Yeah, I know the maths are terrible. I'm sorry.
Yeah.
So you'd agree that there was no transferability without some showing of a relationship between the transferee and the transferor, correct?
I don't necessarily agree to that. I think that goes to the plaintiff's argument that it had been a transfer in violation of the operating agreement.
Yeah, but wouldn't you agree that there are certain limitations on transfers in the operating agreement?
That is true, except the operating agreement does say that while transfers that don't comply with the requirements are void, null ab initio, it also goes on to say that they may be disregarded by the LLC, and it's our position that there is evidence in the record to show that the company did, in fact, disregard the defects in the transfers.
Yeah, so you're pointing out that tension that it says shall be null and void and may be disregarded by the company.
Correct. And that evidence from the record is the 2017 tax return, which was filed in February of 2018. That was a tax return that was prepared by the accountants for the company. Mr. Doyle and his company were not in any way related to the preparation of that tax return. There were distributions made in April of 2018 to all of the members. There was a series of emails in the record in which the plaintiff members are acknowledging that JCB, Mr. Doyle, held an 18.75% interest in the company. That same 18.75% interest is also noted in the 2017 tax return. And this is evidence of a waiver. If they had had an issue by April of 2018 with this transfer, they clearly were disregarding it. So that is very much a question of fact. If you couldn't grant summary judgment to the defendants based on those facts, at the very least, you also could not grant summary judgment to the plaintiff saying that the transfer was void. This was something that really should have been left for a jury to determine, or a finder of fact to determine. It was not something that should have been resolved at the summary judgment level in favor of the plaintiffs. The same token, there is evidence in the record, first of all, that the other members were aware of Mr. Doyle's conviction. But secondly, it misapplies contract law to say that you take this provision the definition of cause, which is common to so many contracts in commercial deals in the city, that clearly is written in terms of what the member does when they are a member. It's not a backward-looking statute. If I could just have 30 seconds to finish. You can't impose a time limit in sub A when clearly you cannot impose that same sub-limit to the rest of the definition.
Thank you.
May it please the court, Kevin Fritz from Meister, Seelig & Fine, on behalf of the respondent. The argument that the appellant makes with respect to the certificate from relief from disabilities, they don't cite any legal authority that a certificate can grant some type of relief from bargain for rights under an operating agreement in a closely held company such as Tradesman. And that's an omission that Justice Maisley seized upon. The argument that the certificate pertains to both the convictions is incorrect. The appellant cite the case law, or excuse me, the statute for saying that where it's one conviction, then one indictment, then it's deemed one conviction. But here you had two indictments 7 years apart, and that's at the record at 277. As the bench acknowledged, the defendants do not challenge the other grounds for cause.
I wanted to ask you, what do you, when counsel talks about any transfer that does not comply shall be null and void ab initio and may be disregarded by the company, doesn't that say to you that the transfer can be the transfer can be disregarded, not that that's a waiver? I think, is that the argument that I'm looking at section 11.1, right? So assuming that the transfer was void, the question is there a waiver? And I'm asking you whether anywhere in this document it says that you can waive that.
Actually, in section 14.5, it says there is no waiver of rights where there's a failure or delay to point out a violation of the operating agreement.
That's what I think. And this may be disregarded. It's not that that is a waiver. It's that the bad transfer can be disregarded.
And Your Honor, the appellants are also asking the court to ignore the clear words, shall be null and void. The case begins and ends right there, as far as I'm concerned, and as far as Justice Maisley was properly concerned.
Well, are they asking us to ignore it, or pointing out that there is an inconsistency and therefore potentially an ambiguity?
I think it's certainly ignore it, because shall be null and void, I don't think requires any parole evidence. It's clear on its face, Your Honor. One thing I must point out, this incorporation by estoppel argument was not raised in opposition to my summary judgment, was not raised in support of their own summary judgment, and was not raised on reply for their own summary judgment, and was not raised in the initial brief filed with this court. So the court should disregard it. But even if you consider it, in the Boslow case, the defendant who was challenging the propriety or the validity of the organization or the partnership was paid advisory fees by that entity. And so the Court of Appeals found, well, you've accepted the benefits from this corporation or this entity. You're now stopped from challenging that it's a valid entity. And we don't have that here. On page 17 of their brief, on the reply, the defendants write, the company also secured benefits from JCB in terms of invested funds and business. What the panel will note is that there's no citation to any evidence after that sentence, because there is no evidence in the record that JCB made any contribution or otherwise provided any benefit to the company. In fact, it's undisputed they didn't. There's an affidavit from my client's representative stating that no funds were contributed by JCB, and we served a notice to admit with that fact, and it was not responded to, and thus it's deemed admitted that JCB did not contribute any funds. Unless the panel has any questions, I will sit.
Thank you.
Thank you.
Okay, where to start? Starting with the last argument, this is a legal argument about the incorporation by estoppel. And it still comes down to, because as Your Honor pointed out previously, JCB was Leo Doyle. Leo Doyle certainly had capacity to take the transfer at the time that he did. And the fact that this argument had not been raised prior to the reply, simply because there had been arguments down below that the transfer was valid. So I wouldn't say that we're barred completely by raising that argument. As far as whether this is a waiver, they acted in such a way that was inconsistent. You can't.
Yeah, but that doesn't, I mean, in the face of a contractual statement, it shall be, and a no waiver provision, I guess my question is, so what?
Well, the so what is still that they treated it that way. And you can't treat it that way and then say, oops, never mind. Because they did make the distributions based on that 18.75%. I'm out of time unless you had any other questions.
Thank you.
Thank you, Your Honor.
Thank you both. U.S. Bank versus Tuberico. May begin. Excuse me?
Good afternoon, Your Honors. Avi Rosenfeld. I am the attorney for the appellant. This is an appeal resulting from the lower court's determination to grant summary judgment. The appellant's position is that the lower court erred in granting summary judgment to the plaintiff in this foreclosure matter because there were certain tribal issues of fact. One was the loan modification agreement. There was a loan modification agreement that changed the terms of the underlying mortgage that the original borrower had signed. The original borrower, prior to signing that loan modification agreement, had already sold the property to the appellant. So under those circumstances, the lender, the defendant in this matter, the respondent, had no authority to provide such a modification agreement. Firstly, it never had a line for the signature of the appellant. The appellant never consented to the modification agreement.
Counsel, wasn't the summary judgment motion below decided on default?
Not in our opinion, Your Honor. The decision specifically set forth that some of the defaulting defendants the decision was granted on default, but specifically the decision referenced the fact that that the appellant had filed an opposition to the motion for summary judgment, and then the court proceeded to address the issues that were raised by the appellant in the decision. The second issue was that the respondent had.
I'll give you 30 seconds to finish. You had 2 minutes.
I had asked for 6 minutes when I first.
And I gave you 2. You don't have opposing counsel. We have your briefs. We've read them. So I suggest you use the last 30 seconds to highlight the most important point.
Okay. The second point is that the borrower no longer owned the property, so they had no authority to enter into a modification agreement. The property was secured by the modification, the loan was secured by the property. Having no longer owned the property, they had no authority to enter the modification. And thirdly, can you enter into a modification agreement where the current owner no longer owns the property? Thank you.
Thank you. People versus Clifton Solomon.
Good afternoon, Your Honor. May it please the court. Natalie Ray of the Legal Aid Society for Mr. Solomon. I'll be very brief. The only question in this case is whether the SORA court erred in rejecting the board's decision to find acceptance of responsibility by my client? We believe the answer is yes. The guidelines make it perfectly clear that in looking at acceptance of responsibility, it is the most recent statement that was made. The board did just that. It looked at his sex offender treatment, successful program, and from there found that he had accepted responsibility.
Was that program mandatory?
Excuse me?
Was that program mandatory?
I can't answer that question, but the board certainly said he was asked to do, it was while he was incarcerated, so I'm assuming it was mandatory. But the board looked and it found that his compliance with the program was enough. And what the people and the court did is go back 3 years to a statement made in 2013 between the plea and sentence, a statement made in the pre-sentence report that Judge Carruthers found a bit disturbing at the time of sentencing. The statement suggested that it had been consensual. Judge Carruthers said, wait a minute, did you plead guilty because you are guilty? In other words, Judge at sentencing wanted to clarify the actual acceptance of responsibility at that moment at sentencing. And Judge Carruthers, who had seen Appellant before, accepted his statement. And then we have 3 years go on. There's the sex offender treatment program, and the board says, okay, he's accepted responsibility. The SORA court ignored the entire sex offender treatment, which one should not do, looked at the statement between plea and sentence, and then rejected the statement clarified to the satisfaction of the sentencing court, saying it's not enough remorse. Well, first, there is remorse, so is not the issue. It may have been at sentencing, but the SORA court had no reason to reject what Judge Carruthers had accepted. Judge Carruthers was not probing remorse, and based on the record, the SORA court never even saw my client who had waived responsibility.
The concern is acceptance of responsibility, right, under Factor 12?
Yes.
Okay, and the guidelines and the commentary talk about, have an important adjective there, genuine. Right?
That's right.
Genuine acceptance of the responsibility.
That's right.
And there was more, I thought there were 2 or 3 statements made at the time of arrest, including a recorded statement, that at least cast some doubt as to the degree to which defendant was accepting responsibility. So it wasn't necessarily an isolated statement made at one point. There were a few statements made that the SORA court was considering in trying to ascertain whether the defendant genuinely accepted responsibility.
I agree, but the court looked at all events in 2013 where there were conflicting statements. There were conflicting statements where he apologized, where he pled guilty, where then he kind of pulled back, and then the sentencing court clarified. But then the entire sex offender treatment is ignored, and you can't successfully do sex offender and not find responsibility, or sometimes you can. May I?
Yes.
And the board looked at what happened in 2016. The SORA court had no basis to find, but for the record, it wasn't enough for it. It wasn't enough for the board, and whatever the SORA court found was not clear and convincing evidence to make him a 3 by adding these 3 points.
And it's your position that regardless of whether the treatment was mandatory or not, it was treatment that was over the course of a year, and SORA found that treatment to be satisfactory as to not increase points.
I don't know whether it's mandatory. I don't know the relevance.
I said what you're saying is it's irrelevant, is what you're saying. Irrelevant whether it was mandatory. It's the substance of the program.
That's correct.
That he completed.
That's correct. And the board made a point of saying it's the time he spent in the sex offender treatment that convinced it that it was clear and convincing evidence of acceptance of responsibility. It's not fair for the SORA court to look back and ignore everything that happened in between.
Thank you.
Good afternoon, Your Honors. Noreen Stackhouse for the people. While defendant did participate in sex offender treatment, his participation isn't a statement at all, and it's not evidence of any actual acceptance of responsibility. It's
So
just,
I'm sorry.
sorry, Your Honor.
So you have the burden here, and you have to show by clear and convincing evidence, correct?
Yes.
So the SORA board found that the defendant's participation over a year in this program specially created for sexual assault inmates was appropriate and satisfactory to find that he did not get additional points, did not get any points, that he had accepted responsibility.
Right.
So how do you meet your clear and convincing burden if you look back, and this is not the most, you ignore the most recent statement?
Well, first,
How do you meet- how do you-
discretion, the ultimate determination is with the court and not the board. The board makes a
It
recommendation.
still has to be by clear and convincing evidence.
Sure, and the clear and convincing evidence that the SORA court looked at was based purely on defendant's statements throughout the course of his arrest and conviction. And at every turn, he has denied responsibility for his conduct. He claimed that the sex was consensual to the police in a controlled call a few days afterwards. He sort of apologized to the victim, but then said, "Oh, I'm sorry if I was too aggressive, not that I
So
violently
he made
raped you."
these statements, he did.
Yes.
Everything you said is true. He made these statements 5 years ago, 5 years prior to, I think he was in jail for 5 years, right?
I believe it was only 2. I think he got out early. I'd have to go back to my brief.
Okay, whatever it was, I'm not sure, but I think he was sentenced to 5 years.
Yes.
So 2 would be particularly early, usually it's
I believe he
two-thirds
went
of
in
the
in
time.
2013 and got out in October of 2015.
Okay, so in that time, he took this program, but the judge doesn't have to view that at all. The judge can ignore this program and
There's no
just rely on the statements.
The judge is looking at the total record to see if there's a genuine acceptance of responsibility for the defendant's conduct. The purpose being that a defendant that hasn't genuinely accepted.
I understand the entire purpose
Yep.
and what genuine means. My question is,
There's no inference to be drawn.
my
especially if
question is, what information did the court have about this one-year-long program that led the court to believe that one-year program of treatment was insignificant and that the defendant had gained nothing from it, such that clear and convincing evidence, and really it's about the burden of clear and convincing evidence when you have the board saying, hey, we have clear and convincing evidence, this was enough, and the court saying, there's no clear and convincing evidence that that was enough. I'm relying on this previous statement.
There is nothing from the sex offender treatment in the record that shows defendant made any statements during treatment or that he accepted responsibility or did anything.
Whose burden is that? Isn't it yours?
It
When
is,
the
but
board has said that that program is clear and convincing, isn't it your responsibility to present what
And the
happened
people
or didn't
did
happen?
in the form of defendant's statements, such that when.
I'm sorry.
May I finish, Your Honor?
I didn't hear what you said.
The people did present evidence in the form of defendant's own statements, which at every turn, including after he pled guilty, whenever he was asked
I'm
to
asking
say
you
in
about
his.
statements during the program. If the board said there's clear and convincing evidence, and the court is saying, I'm looking at what he said at plea and sentence, and the board since then has given the last statement, which the law says we have to look at the most recent statement, and they said that was clear and convincing. I'm asking you, what your burden, what clear and convincing evidence you presented to show that that program,
To
that
me,
nothing was said.
the sex
You have
offender
to come up
treatment
with
is not a statement. The last statement was what.
the treatment. Did anybody talk to the counselors at the sex offender program?
There was no evidence of that.
No evidence of that. What do you mean you didn't? It's your burden to present what happened at the program. What evidence did you present of what happened at the program?
The people presented the evidence, what happened to what the defendant said to probation. If defendant had.
Prior to the program? Is that what you were speaking to?
No, I'm saying that if the defendant wanted to counteract that representation, he could have presented his own statements of what.
Yeah, but it was your burden. This is what I don't understand. It's your burden, isn't it?
It's not our burden to prove that defendant accepted responsibility by making statements in sex offender treatment. If the defendant
It's what was before the court was the statement, I'm sorry, what was before the courts was the board's indication that he finished the program and that was clear and convincing evidence. So how did you meet your burden to say that wasn't clear and convincing evidence?
Again, completion, we don't know that he did anything in sex offender treatment beyond sit there quietly. We don't even know if he listened to it.
How would you know if you didn't explore it?
I don't know if they explored that. That's not in
You
the record.
explored it, the people.
Right.
Did you explore that?
Me personally, no.
Whoever in your office is supposed to. You're here arguing, so I'm assuming whoever was at the
I
trial
didn't see
court.
any evidence of that on the record. The people presented evidence of the defendant's own statements. There were no statements presented from sex offender treatment.
Excuse me, Justice Remy.
Yes, sure.
One related.
Yes.
Counsel, if I understand you correctly, there were no statements before the SOAR court in conjunction with the treatment that defendant received while he was in prison.
Right.
Under which factor, if any, would the SOAR court give consideration to the successful completion of this kind of program?
There's actually a factor where you would be assessed points if you refused to participate in the treatment or ended the treatment early. So if he had refused to participate or ended the treatment early, he would have been assessed an additional 15 points. So essentially, the RAI does credit people with successfully completing sex offender treatment in that way.
So under factor 12, he helped his cause by not getting kicked out of the program.
Essentially, yes.
Okay. Thank you.
Thank you.
Just 2 points. One is section factor 12 and getting points for being rejected is not the issue here. It's a misunderstanding of the risk assessment instrument. The New York risk assessment instrument gives points for what experts have decided increases the risk of reoffending. It doesn't, it doesn't if you do something good, like accept responsibility, you don't get points for that. That's how the New York's risk assessment instrument works. It's by looking at actions that are negative that are going to increase your risk. In this particular case, there is the board had found that there was clear and convincing evidence from the treatment that he had accepted responsibility. Nothing more was presented.
Whose burden was it to present something on that issue?
On the people, once the board has decided that he doesn't have points, if they want points, then they have to present clear and convincing evidence that they deserve the points, but they didn't present anything.
Is there anything in the record about that program, about what the program entailed, about what the defendant did?
I mean, all these programs are similar, and there's a lot of, of acknowledgement of your actions. I'm sure your honors have seen. I mean, these programs have, these different stages where you accept different, where you talk about your trauma and all these things. They're all the same. And the board, looking at those, said he's accepted responsibility. And in this particular case, Your Honor, this is going from a 2 to a 3. This is the difference between where you can live for 10 years of supervision. It is dramatic. And in this case, there's simply the people didn't satisfy their burden, and the court didn't point to anything besides the statement at sentencing to say it was not genuine. Thank you very much.
Thank you. Thank you both. Gibbs versus Manhattan.
Good afternoon, Your Honors. May it please the court, Daniel Dugan for the appellants, Ms. Gibbs individually and on behalf of her son. The Supreme Court erred in granting defendant's motion to dismiss, as in this instance, the appellants have met the pleading standards in stating cause of action for negligent supervision of students, negligent supervision of employees, and breach of contract.
Let's start with the negligent supervision of students. How can a school control a rumor mill?
Your Honor, they have a duty to control rumors. Lehman specifically sets forth in their student handbook.
No, how do they go about doing that, though?
Well, Your Honor, the question of how they go about doing that is a question for the trier of fact.
Well, there has to be something that would show to be efficacious, right? I mean, you know what I'm getting at. Social media goes on outside of the school in many times, I mean, maybe sometimes during the school. But don't you have to show that the school could have done something that had some efficacy in shutting down the rumors?
Your Honor.
Let's allege facts to that would tend to show that the school could do something that was efficacious.
Well, Your Honor, they assert under their anti-bullying and harassment policy that they have jurisdiction extending outside the school walls to include cyberbullying. They specifically define bullying as rumors. In this instance, Ms. Gibbs specifically asked the school to take action to prevent these rumors from spreading and that they were doing irreparable harm to her son's reputation and that they were continuing. The school acknowledged that they could not provide a bullying and harassment-free environment despite asserting that they would do that in their own student handbook. And I go back to the standard as to which actions they are to take to prevent those rumors should be left up to a trier of fact. We were specifically put on notice as to what was happening. There were rumors being spread that...
So, counsel, but I'm coming back to the same thing as to what the school could do. What do you allege in the complaint was the proximate cause of the injuries of the infant?
Right. The proximate cause of the injuries was Lehman's inaction in preventing these rumors from continuing to spread and clearing the student's name unequivocally.
Okay, and we are, for a moment, the finders of fact. Argue to us how, as Justice Moulton was prodding you a moment ago, how could Lehman have satisfied that? How could they have cleared your client's name? Or what could they have done to mitigate against that rumor mill?
Sure, there are a couple of actions that they could have taken. They sent out 2 different notices, communications to parents following him being cleared by the NYPD and the school of being any threat. The communication that they sent out identifies that this student will not be on campus anymore, that there's no longer a threat. They also identify the additional security measures that they're going to take now to protect their student body. While the school indicates that they never identified this individual by name, Ms. Gibbs made it clear to the school that the rumors were spreading and parents were coming to her. Everyone knew who the child was. They never sent out, while they sent out notices regarding additional security at the school, they never sent out any information or made any attempt to stop the rumors from continuing to spread.
So a strongly worded email or other notice to the student body and their families that this person, an affirmative statement, this particular person does not present a threat?
Right, and one more specific point to that, should the rumors continue to spread, which they did, Lehman identifies rumor spreading, cyberbullying as a major infraction of their student handbook. Again, this was on a motion to dismiss. There's no indication and there's no knowledge that they ever performed an investigation as to who was spreading these rumors amongst the student body, and there's no indication that anyone was punished for spreading these rumors, both of which are provisions that they lay out in their own student handbook.
Did Lehman warrant in any way, shape, or form in that handbook what the consequence would be or what remedy was available if Lehman failed to provide that that bully-free environment, if you will? Or failed, maybe a better way of putting it is, did they warrant or specify what remedy or relief would be available if Lehman was unable to provide the, didn't follow its anti-bullying protocols that were laid out in the handbook?
If they identify if a student is, violates the student handbook in terms of bullying an individual, it's to be reported to the staff. The staff will investigate. This is laid out right in Appendix B of their student handbook that they will investigate, and then it's up to the staff to determine discipline. But like I said, they identify it as a major infraction.
So counsel, let me just ask you, did you bring a breach of contract claim?
Yes, Your Honor.
Okay.
There is a breach of contract claim.
And the breach is?
That they violated the provisions of their own student handbook, which it's well settled that the student handbook forms the contract between a student and their school.
Right,
So there was,
in terms of because they didn't eliminate the bullying?
they didn't take the actions that they stated that they would in their own student handbook to prevent these rumors from continuing to spread. They were specifically put on notice by
What specific section are you saying they breached? That's what I'm trying to figure out. I mean, it's a general thing. We don't like bullying. No one likes bullying. We are going to do our best to get bullying out of the school. I'm asking you, what specifically do you say that they did, that they breached?
Again, Appendix
You
B.
don't like what they did, right? You don't think it was enough, but what did they
Their,
breach?
their inaction is the breach. They didn't follow their student handbook, they didn't investigate, and they didn't punish the
Well,
other
they did do
individuals.
an investigation, right?
Again, this was a motion to dismiss. They did an investigation into the plaintiff student, into the allegation that he made a threat.
So in the student handbook, it says, we will investigate all cases of bullying?
Yes, Your Honor.
What does it say
It's
specifically?
in the record.
Yeah, what does it say? That's what I'm curious.
R104. So we can start with reporting all concerns relating to harassment or bullying should be reported immediately to a teacher. Again, this is other faculty members. Excuse me. Then it continues, when the school becomes aware of harassment or bullying that is within the school's jurisdiction, and as I stated previously, jurisdiction extends outside, the situation will be investigated as soon as feasible. The scope of the investigation will depend on the nature of the complaint. The school expects all persons to cooperate fully with the school's investigation, including making postings on the internet or text sent over phones available for inspection.
So
What's the record citation?
That's R104.
And that's the provision you said, your allegation in the complaint is they did no investigation. Okay.
Correct. And then just specifically to that breach of contract claim, the email from the school to Ms. Gibbs when she sought reinstatement for him stated that we can't provide a harassment-free environment, rumors will spread. So that, again, that goes to 103, 104.
I just want to get, you're saying they did an investigation to what was going on with your client, but no one investigated to find out who the anonymous reporter of something that ended up being invalid was by questioning students, bringing them into the office. There was none of that. That's what you're saying.
Again, I want to stress that this was a motion to dismiss, so there was no discovery.
Okay.
But the plaintiff asked action be taken, told them what the damage would be.
I just wanted to be...
Damage continued.
Okay, thank you.
Thank you.
Let's hear from opposing counsel.
Good afternoon. May it please the court. My name is Craig Commissar from Catton Mush and Rosenman. I'm here today to ask the panel to affirm the Supreme Court's decision dismissing appellant's amended complaint in its entirety. I'll keep this fairly brief because it's a straightforward case. In February of 2018, Lamont was contacted anonymously by someone who had seen provocative social media posts made by appellant's son, B.E.
No, let's go directly to the breach of contract claim.
Sure.
Counsel claims that you breached your obligation to investigate the source of the claim that this young man may be dangerous. How do you respond to that?
That's not pleaded in the complaint. The amended complaint does.
Well, that's what I asked. I thought I just asked that to plaintiff.
Yeah,
I
no,
said, did you plead
that's not,
that
it's
breach
not,
of contract claim?
that's not pleaded in the amended complaint. All the panel needs to do here is look at the amended complaint, and this is what the Supreme Court correctly held was that that plaintiff simply pulled language from the handbook, but the allegations of the complaint, quote, lacked any factual basis to support a claim for breach of contract, express or implied. There is no allegation with respect to conducting an investigation. It's not there. So that's.
Well, what they say on their third cause of action for breach of contract at the record at page 41 and 42 is that in addition to the above, we repeat and allege the above allegations, and then Appendix B, which I believe your friend just mentioned, of the Family and Student Handbook, contains a provision, quote, Lehman Manhattan Harassment and Bullying Prevention Policy, end quote, and that Lehman failed to create an environment in conformity with certain quoted provisions of the Harassment and Bullying Prevention Policy.
Correct, Your Honor. So as far as the allegation that that Lehman failed to create an environment where bullying and harassment are never tolerated, I mean, that's completely conclusory, and conclusory allegations are not sufficient to state a cause of action. I mean.
Well, so he says in above in his complaint that the following narrative occurred. Now, you don't have to agree with that narrative, but here's my alleged narrative. And as to my breach of contract, here's a specific provision that provides certain rights. I'm claiming this was breached as a result of what I recited above. So is there a particular element or elements for a breach of contract action that this pleading is conclusory with respect to?
All of the allegations in the complaint are conclusory and unsupported by any specific fact. So the argument for breach of contract is based on several false premises, one being that bullying was tolerated by the school. I mean, that certainly is, that's conclusory A, and B, it's untrue. Appellant alleges or argues on appeal that BE was punished, but there are no facts in the amended complaint demonstrating that that he was punished.
Well, he did argue that as a result of this, he was suspended, and his mother had made some inquiries as to getting him reinstated, and that he wasn't permitted to return.
That's not an accurate statement of the facts. The student was already serving a suspension at the time that these incidents occurred.
But that's a product of a footnote in a brief, right? This was a 3211 motion where we've got the complaint and I think the handbook and a few emails that were between the mother and someone at the school. That's our factual record at this juncture, right?
Correct. The fact of the matter is that the student was serving a suspension at the time that these social media posts occurred. In consultation with the school, the appellant decided that it would be best for the student to remain out on suspension, given the environment, and she actually requested and received a tuition reimbursement, and also the student continued to receive credit from the school, academic credit from the school. I just want to, if I may, just 30 more seconds. With respect to the issue that was raised of clearing the student's name, I think one of you hit on this. The appellant conceded that multiple emails were sent out to the school community saying there was no threat to the school, that that the NYPD had conducted an investigation. No threat had been found. I mean, if that doesn't clear the student's name, So I will rest there unless the court has any further questions.
Thank you.
Thank you.
Sure. So in addressing the argument that the breach of contract cause of action, it's conclusory in nature, the allegations and the complainer specifically pled that Ms. Gibbs spoke to the head of the school, and she was the individual that stated, and it was memorialized in an email, it's paragraph 16 of the amended complaint in the record at page 39, that the school, the possibility of a return could reignite the abuse and disparagement. Those were the words of the school. And as you know, again, I'm sorry, that was Ms. Gibbs, but she stated that, I don't believe there'll be a lot of learning going on. I think your son will be a distraction. It isn't a conclusion in the pleadings. This is what was stated by the head of the school to the appellant here as to why the student was prevented from coming back. And as Your Honor mentioned, the issue as to regards to whether he was out on a suspension, that's not the reason why it was stated that he could not come back to school. They simply
I'm
said—
sorry, because you only have a moment. Putting aside the breach of contract,
Sure.
and you have two negligence-based causes of action. And in deciding whether there's a duty, that's a question of law. And one of the things we have to consider is policy concerns. And one of the potential policy concerns I think here is making schools insurers of liability under these circumstances, which unfortunately are probably far too prevalent, bullying. And so are we going down a slippery slope here if we were to recognize a cognizable claim under negligence, not your breach of contract, but under your negligence theories?
No, because just as in a physical tort, a school wouldn't be liable for an impulse on the part of a student. As some courts have found, and it's cited in the reply brief, where the school is put on specific notice of the bullying that's occurring, and the harm that's being caused, which is what happened and what is alleged here, then they do have a duty to take action. It's set forth in both the handbook, case law, and DASA sets forth that as well. Thank you, Your Honors.
Thank you both. 3rd and 60th Associates versus 3rd Avenue, M&I.
Good afternoon, Your Honors. James Schwartz from Cerulli Shanks for Plaintiff Appellant, 3rd and 60th. This is a case in which the plaintiff landlord's claim against defendant guarantors was dismissed as a matter of law based upon the guarantee law that the City Council passed in May of 2020.
Yes, we're familiar with the facts.
Last November, a federal district court upheld that statute against a constitutional challenge upon, among other things, a contract clause claim.
So in this case, you had a lease. In this case, the facts of this case, if we could bring it to the facts of this case, you had a lease and there was a non-payment action.
Yes.
And then there was a stipulation drawn up.
Yes.
And the stipulation allowed the tenants to be in under use and occupancy. And they they failed to pay at some point, and there was a 3-day cure period. The 3-day cure period fell on a Monday, the Monday prior to the time that this statute went into effect. So isn't that the problem that you're having here?
No, it's not, Your Honor, because the guarantor's liability was established from August 2019, months before the COVID problem, the COVID statute, the guarantee law set up this exemption period starting on March 7th, 2020. And because this was a guarantee of payment, the guarantors became liable every single month on the first day of the month when rent was not paid. The stipulation was entered into on February 21st, again, before the start of the exemption.
But that was a new agreement. You started the new agreement before then. That's true. And then every month, they were supposed to comply. But when they fail to comply, there's a 3-day cure period. How do you deal with the cure period?
They failed to pay the
Right,
rent
right.
on March 1st, which was before the start of the
Yes.
period. Okay. The issue then is, what does the cure period mean? Liability is established by March 1st for all of the rent that had accrued. The cure period, a cure, is designed to free the guarantors of the tenant. I mean, the guarantors weren't even parties to the stipulation, but it's designed to allow the tenant to free itself theretofore existing of liability that existed before then.
Counsel, are you saying that you could have sued without giving a default notice
Yes.
under your stipulation?
Yeah,
You are not required to give the 3-day cure period.
To the guarantors who are not parties to the stipulation, the answer to that is yes. I do need to raise one item.
I don't see that. I mean, if they're only liable to the same extent that the tenant is liable, and the tenant, you could not, no matter what, you had to give the 3-day cure period. Whether or not they paid rent in March, you could not sue them and establish a liability until you gave the 3-day cure period. That's basic real estate, commercial landlord-tenant law.
The guarantors were not parties to this, and the guarantee, not only are they guarantors of payment, but the guarantee itself says that they are also jointly primarily liable. That's in the guarantee. I do want to point out one item, though, Your Honor, which last week the Second Circuit reversed the district court in Melendez versus the city and reinstated the contract law claim. And as I have copies, if the court wants to see the decision, but the claim that the statute is unconstitutional on contract clause grounds has been reinstated, and the plaintiffs in that case are now free to show or to prove that, in fact, the statute is unconstitutional. Thank you.
Good afternoon, Your Honors. Edward Kushmakov, Jacobs PC, on behalf of the respondents. Before I begin, I'd just like to address a couple of points that opposing counsel has raised. The first one, I'll start at the end, was Melendez, the case that you just referenced. The issues that opposing counsel has just raised are not on for appeal. If the record clearly shows that the appellants have not even touched upon the contracts clause, they had no intention of arguing it on this appeal, and therefore Melendez is completely irrelevant.
Counsel, how do you address your adversary's statement that the stipulation of settlement had no effect on the guarantor's obligations? That's what I'd like to hear you talk about.
Absolutely, that's a very fair and excellent question, Your Honor. First of all, the argument they're just making was not raised in the lower court at all. Second of all, if I may just point everybody to paragraph 14 of the stipulation. Essentially, paragraph 14 of the stipulation is a mergers clause. Everything, every agreement prior thereto, but for the lease, is merged into that stipulation. Now, this means that the guarantor's liability, or in our case, personal liability upon the guarantors could not have attached until there was a failure to cure following notice.
But how could the guarantors be bound by the stipulation in the action to which they weren't a party?
The lease references the guarantee. Moreover, the guarantee itself is an agreement between the landlord as well as the tenant, and in fact, it is for the benefit of the tenant.
And so,
Granted
are you arguing certainly that the guarantors are third-party beneficiaries of that
Absolutely.
agreement, right? Because they get the benefit of the stipulation, they don't have to pay, they're out of the lease early, all their obligations change with respect to the stipulation.
Absolutely, Your Honor, and this is exactly why a stipulation was entered into, so that parties can work their differences out. These are the terms that were agreed upon. Everyone knew who they were. Everyone was represented by counsel. It was jointly drafted. And for the reasons stated in our papers and the reasons stated just now, we believe that the lower court's decision should be upheld. If there are any more questions, I'm happy to address them. Otherwise, I rest in the briefs.
Thank you.
Thank you, Your Honor.
Your Honors, I would point out that paragraph 3 of the guarantee says the liability of guarantor hereunder is direct, unconditional, and coextensive with that of tenant, and may be enforced without requiring landlord first to resort to any other right, remedy, or security. I would also point out that this court on May 21st, in the 558 7th Avenue versus Times Square photo case, stated, and two of the justices sitting here today, Justice Renwick and Justice Mazzarella, you were on that panel, that the guarantee law does not apply to obligations that are outside the exclusion period. And here, what we are here,
That case was different because there were facts that made that relevant. Here, those facts don't exist.
Well,
there are very different facts in that case.
Well, Your Honor, the legal issue, it seems to me, from reading the opinion, and there may be facts that were not in the opinion, but reading the opinion says that where the obligation is outside the exclusion period, the guarantee law does not apply. And as to these guarantors, they became liable every single month, month by month. Thank you, Your Honors.
Thank you. Thank you both.